I received the instruction, Lordship. 2 weeks time may be given to file affidavit.
You have informed the other side.
I have informed the
Consent of the other side. Mr. Anupadhyay and counsel for the PSC
Respond.
prays for
2 weeks
Uh,
time.
prays for 2 weeks time to file affidavit in opposition in the matter. There is allowed list after 2 weeks.
Obliged, Lordship.
May it please your lordship. When I pray for a listing of a matter for
Listing,
application,
please give it to the courtmaster.
that will
All prays for listing, give it to the courtmaster.
The content of the petitioner side, I beg to mention item number 55. We are required to file an affidavit in this matter. 1 week time may be granted.
55.
Yes, your lordship. May I pray for the respondents, APGCL.
Okay. How much time?
Lordship, 1 week's time.
1 week's time. Okay. You have informed the other side
Yes, your lordship.
Okay.
I think
with consent of the other side. Mr. HR
HR
has learned counsel for the respondent.
APGCL. 1, 2, 3.
For the respondents placed for and granted. How much time?
1 week time.
1 week's time to file affidavit in opposition in the matter.
Yes.
List after a week.
Obliged.
may please item number 49 lordship and the adjournment for today list after 2 weeks. 49 review petition lordship. HRS will
49.
have the case. 49.
Okay. What was the result yesterday?
Lordship. Sorry to say, lordship.
Huh?
Sorry to say.
Okay. Okay. No, because yesterday I had a what you call net outage at my
Lordship.
place. I'm not aware of anything. Yesterday was a peaceful day for me. Okay. Both sides are represented. List after
2 weeks lordship.
2 weeks has paid for valid counsel for the petitioner. Okay. Yes.
My pleasure, Lordship. Lordship, with the consent of the other side, I'd like to mention item number 38 of this list, Lordship.
38.
Yes, Lordship. In this matter, we have received our Paravas comments. Lordship, may kindly give us 2 weeks time to file our affidavit, Lordship.
Okay. You have informed the other side.
Yes, Lordship.
Consent of the other side. The learned counsel for the Corporation Department prays for and is granted 2 weeks time to file affidavit in opposition in the matter. List after 2 weeks.
Much obliged.
Please, your lordship. Supplementary list item 56, my lord. Some defective in this petition, my lord. Kindly allow me to withdraw this petition and liberty to file a fresh, my lord.
Okay. 56.
56, my lord.
Okay. Upon instructions, Ms.
Disabora.
DJ Bora, learned counsel for the petitioner, seeks to withdraw this writ petition and seeks liberty to approach again as there is some inadvertent error in the writ petition.
Obliged.
PHE, who is there? Mr. Anupadhyay and standing counsel for PHE is present. Matter since dismissed on withdrawal with liberty as paid for.
May it please lordship. In regard to item 57 supply, we have filed an additional affidavit. Kindly call for the recall.
May I please, your lordship. I beg to mention item number 25 of today's daily list, lordship. Lordship, can we pass out for the day, lordship, as there is some personal difficulties, lordship.
Okay.
25.
You have taken consent of the other side?
Yes, lordship.
You're for?
Industries and Commerce Department.
Okay. With consent of the other side, the standing counsel for the Industries and Commerce Department pays for adjournment. Next, password for the day is paid for. Yes.
Obliged.
Please, your lordship. Lordship, with regard to item number 19, I'm seeking an adjournment for today, lordship. The conducting counsel has some difficulty. I've informed the other side is here, lordship. Item 19.
9. What is this IA for?
We
file an application for vacating in interim order lordship.
You taking consent?
Lordship,
I'm for the respondent.
respondent.
No, you're for the respondent 2 to 4.
Yes.
This petitioner is Mr. Mangan.
Yes.
Lordship, I am appearing on his behalf, Lordship. I'm A Talukdar, Miss A Talukdar.
You're
Lordship.
praying on his behalf.
Lordship.
Okay. Both sides are represented. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after,
Any day, Lordship, and
Maximum 13th if possible.
Lordship.
Lordship.
make it 12th,
Lordship.
12/6/2024.
Lordship, interim order shall continue till then.
But that is the problem after vacating application.
Lordship, only for today, I'm seeking
Well,
at.
they have also filed a contempt, Lordship. That may be listed along with this. Contempt case number 115/2024.
Because you see 226(3), here the date is already over. 2 weeks have gone by. This was filed long back. 2 weeks have gone by long back. So by operation of the constitutional provision, this interim order is not there. That's why I was thinking, so just see item 19. March 21st. Giving the issue of the provision of provision of Article 226 within bracket 3 for constitution of the next date. Interim order passed with this stands extended to the next date of listing. The issue relating to clause 3 of Article 226 is kept open to be decided on the next date.
Maybe contempt may be listed along with this case.
Okay.
115.
List, next different list. On so and so along with
Contempt civil case number 115/2024. Much.
Much obliged.
Right. I think so item number 2, my lord. The contempt matter, my lord, relating to bench height matter, my lord.
oh, acha.
2.
Mr. M. Hussain, learned counsel for the petitioner. It's fairly submitted that this matter gets to bench 5. Mr. The registry shall examine and list the matter before the appropriate bench.
मतलब on Friday वाला thing possible.
On Friday. Right. Okay.
Obvious. Two.
May it please your lordship. Lordship, I would like to mention item 21 of the daily list. Let the matter be adjourned for 2 weeks, lordship. 21.
You're for?
KK Mahanta, Mr. KK Mahanta.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. List after
2 weeks.
2 weeks. Okay.
That's what.
Please, Your Honor. With the concern of the other side, I beg to mention item 47, my lord. In this case, yesterday the respondent number 3 has filed affidavit in opposition, my lord. We need to file a reply. Kindly, 3 weeks may be granted.
Okay. On the prayer made by learned counsel for the petitioner. List after 2 weeks was whenever in file a affidavit in replying
After
the
3
matter.
weeks, man. After 3 weeks.
3 weeks. Okay.
And my lord, regarding my lord, item 11, my lord, Mr. S. Borthakur has some personal difficulty with the, my lord. Let the matter be come up on Friday, my lord, day after tomorrow. Motion matter, my lord.
Okay. Friday. List one. Sorry.
Much of-
Learned counsel for the petitioner.
Much of
Yes.
May I please, your lordship? My lord, I beg to mention today's motion item number 15, my lord. Lord, what has happened, my lord, in this petition, we have challenged an ordinance, my lord. And the similar matter has been heard by the division bench, my lord. Perhaps it has been wrongly come up before my lordships, my lord.
Okay.
My lord.
Also, it's represented, Mr. A.R. Bhunyal and counsel for the petitioner has submitted that.
Item 15.
What has been challenged?
My lord, the Assam Muslim Marriages and Divorce Registration Act of 1935 had been repealed. By
Repealing act you have challenged.
Yes, my lord.
Okay, the.
It's an ordinance, my lord, not an act. my lord.
That repealing ordinance has been challenged
My lord.
in this repetition. And accordingly, he submits that the matter be listed before the appropriate bench. Next paragraph. As the provision of a repealing act has been challenged, the registry shall examine and place it before the appropriate division bench.
My lord. Obliged.
Daily list item 1 for motion.
Means you have any instructions?
My lord, affidavit has already been filed, my lord. We have also filed our reply, my lord.
Lordship, I fix it for admission hearing, Lordship.
Oh. Okay. Both sides are represented. Next, it is noticed that the respondents have filed their affidavit in opposition and the petitioner has also filed an affidavit in reply. Next one. Nonetheless, notice of motion has not yet been issued in this case. Accordingly, let a notice returnable on 19/6/2024 be issued without requiring any steps to be taken as all the respondents are represented. List on in the admission column.
My lord, can it be after 19, my lord? 2-3 days after 19, my lord.
Okay, okay. 24th June.
Okay.
Obliged.
Obliged, your Lordship.
Oh, actually, no, not on 24th. It will be 26th.
26.
26th, 24th, there is this matter.
Item 3.
Please, yes, Lordship, contempt petition has been filed by the petitioner.
What is the date of the order?
Lordship, annexure 1 for 11 page 16, Lordship.
Raising. Mr. M.K. Barar, Counsel for the petitioner. Next, alleging willful disobedience of order dated 12/5/2023 passed by this court in WBC so and so. Present contempt petition has been filed under Article 215 of the Constitution of India. I'm sorry, Section 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India. Notice returnable in data after 5 weeks. Take steps within 2 days, returnable on so based on so and so. The tendency of this contempt petition shall not be a bar for the respondent authority to comply with the order of the court. Who is there for revenue? Mr. You see what is happening? Contempts are being filed. Contempt started to come in. Your 162C orders are not being passed. Contempts have started coming.
Yes,
Officer will be in trouble.
That's it. I get it.
This is one of that contempt cases. Yes, item 4.
Wait, is your lordship? Lordship, can you pass over the matter for a timing, lordship?
This one here for us, what is your instructions?
Well, these are our workers, well, we are willing to consider matters. The fixed pay matters. Fixed pay part matters, their prayer is to fixed pay matters.
How much time do you need to take a decision?
1 month, my lord.
1 month, okay. Heard miss?
As thus.
As that's and counsel to the petitioners. Also, Mr. D. Gogoi, Leonard, standing counsel for the Forest Department. As well as Forest Department representing respondent numbers 1 and 3 to 6, and Mr. Harper Pujari, Leonard, standing counsel for the Finance Department representing respondent number 2. Next para. The petitioners project themselves to be working as casual workers in the Kaziranga National Park for more than 10 years. And they are, and by filing this petition in Article 226 of the Constitution of India, they claim to be granted a rigorous pay scale in terms of judgment of this court in the case of Upen Das. You find out that Upen Das.
It's 45 of 2000.
No, that we know. But what is the name? It is State of Assam versus Upen Das or Upen Das versus State of Assam? Why do you?
State of Assam and others versus Upen Das and others. Paragraph 22 and 23, man.
Why 2 more lines you can't write in your prayer? Next paragraph. The next, the Learned Standing Counsel for the Forest Department has referred to the previous orders of the court and has submitted that the authorities require some more time to take an appropriate decision in the matter, and therefore prays for some time to obtain instructions. Next paragraph. They have it. They have it. I just have to tell them that.
Only that
Since I,
paragraph 22 and 23, if the petitioner fulfill, my lord, inevitably he will get the benefit. Only that benchmark of 10 years, my lord, with effect from retrospectively.
but they're saying it, but he needs some time to
He
take a
will
decision.
verify.
They will verify the status of the petitioners and then take an appropriate decision. So next paragraph. Accordingly, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the runners, the Departmental Counsel in the course of the day. Next paragraph. The pendency of this writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioners and to take an appropriate decision in the context of the prayer made by the petitioners in the writ petition. Just after 4 weeks.
Item 5.
Yes, Lordship.
This is the matter pertains to non-payment of the area family pension.
But there was a direction to obtain instruction, my lord. I pray for a very short date, my lord.
We are issuing a notice of motion because otherwise it will not come to its conclusion. That Mr. A. Borod and counsel for the petitioner, as well as you are applying for the education department?
No, my lord, pension department, my lord.
Pension department, okay. For education is there? Your name?
S4.
Name is S. Kunal, and standing counsel for the elementary education department, representing respondent numbers 1 and 3. And Mr. G. Pegul and
Respondent number 2.
counsel for respondent number 2. And Mr. Arba Pujai, and standing counsel for the finance department, representing respondent number
4 and 5, my lord.
4 and 5. Next one. The petitioner is agreed by non-release of arrear family pension on and from the death of his father on 22/7/2013 till 8/4/2022. Accordingly, this writ petition. Next paragraph. Issue notice of motion returnable. We give you 2 weeks time. Returnable on 19/6/2024. So requisite extra copies of the writ petition be served on the state and departmental counsel in course of the day. Next, the pendency of this writ petition shall not be a bar for the concerned respondent authorities to examine the claim of the petitioner and to release arrear family pension, if not already done. Next, list on so and so.
That's why the order dated 9/4/24, my lord. I have already served the extra copies.
You
If
have
required,
to-
I can.
I have already communicated, my lord.
Extra copy don't you? It is submitting that extra copies have already been served on the rest, state and departmental counsel. Okay.
Well, obliged.
Item 6.
Hey, my lord, I am challenging the so-called of this matter as well as the order, my lord, to initiate the independent proceeding, my lord. Now I am challenging the competency of the SP, my lord, of Karbi Anglong, my lord, whether he was empowered to issue so-called notice or not, my lord, in view of Rule 37C of my lord Assam Police Manual Part 3, my lord, because he is being appointed or promoted by the ADCP, my lord. Now, my lord, kindly
Who is
see-
the authority who has passed the order?
the page number, my lord, 53, my lord. This is the so-called notice, my lord, issued by the Superintendent of Police, my lord.
Yes, what is your instructions?
Yes, Lordship, he is being the appointing authority of the district Lordship, so he is competent to issue this. I have, yes, Lordship, as per schedule to the para 12 Rule 66 of Assam Police Manual Part 3. Lordship, I have the written instruction.
Yeah.
But this issue has been settled by our High Court Divisional Bench in 1976, my lord, in Gojendra, my lord, Sondra Bora, my lord. Where? The Division Bench, my lord, interpreted by my lord, Rule 66 and 37, my lord. Exactly on the same issue, my lord. Assam Police Penal Part 3, my lord, Rule 37, my lord. Is page number, my lord, 257.
$57. Weeks.
Their judgment to refer for release. Huh?
Rule 66 or 37.
Judgment is
Oh, oh.
refer for release a judgment.
1976. 1987
So?
to July 183. I'll give the 37C minutes. Okay. Part 3 minutes.
What is the post of the petitioner?
He was promoted from the post of my lord, the ASI my lord, to Sub Inspector of Police my lord, UB my lord. So my lord,
Inspector.
Sub Inspector of Police my lord.
Sub Inspector of Police.
Yes, my lord. That's why my lord, from ASI to SI my lord, Rule 37 will come into play my lord.
Lordship may issue a short notice, Lordship. Let us also come up with this, Lordship.
Just now.
But in the first parameter, facts have been married. In para 3, C, at the 11th bottom of the petitioner therein was promoted by IGP my lord. And so far Rule 66 is concerned, it has been dealt with, my lord, in paragraph number 5, my lord.
Where is the order of your promotion?
My lord. Page 27, my lord.
Serial number?
Yes, my lord. Serial number 35, my lord. Page 35, serial number 482, my lord. ASIUB Sanat Kumar Budoy, PC Guwahati, Nagaon, OBC Karbi Anglong. In page 36, my lord, it has been issued by the Additional Director General of Police Admin, my lord. And at a relevant point of time, my lord, he was working, my lord, in Police Commissioner Guwahati, my lord. Therefore, in clause 2, my lord, copy forwarded to
Then
Commissioner.
this show cause notice has to be stayed then.
Yes, my lord.
Third, Mr. As whatever and counsel for the petitioner. Also had Mrs. M. Bhattacharya, Leonard, additional senior government advocate appearing for the respondents. Next slide. The validity of the show cause notice dated 19/2/2024 as well as order dated 17/3/2024 by which departmental proceeding was initiated against the petitioner are being challenged in this writ petition filed under Article 226 of the Constitution of India on the ground that the is the is the promotion order dated 7/8/2021 was issued by the issued by the order of the Director General of Police Assam, the Superintendent of Police Karbi Anglong, could not have initiated the departmental proceeding against the petitioner. First, issue notice, including notice that prepare for interim relief returnable on how much time, Mrs. Bhattacharya?
Lordship, 4 weeks, as Lordship is
Uh,
intervening this Lordship.
4 weeks. Next one. As the learned additional senior government advocate has accepted notice on behalf of all the respondents. Requisite extra copies of the writ petition we served on her in course of the day. Next one. Next one. As the petitioner has been able to demonstrate from Annexure 2 to the writ petition that his name appears in the order of promotion at order of promotion dated 7/8/2021 at serial number
482, madam.
482, which was issued by the order of the Director General of Police Assam. It primarily appears that the initiation of departmental proceeding against the petitioner White show was notice dated 19/2/2024. Was by an authority who is not the appointing by an officer who is not the appointing authority of the petitioner. Accordingly, the operation of the proposed notice dated 19/2/2024. Where is the 17/3 order page?
65, madam.
Page
65, madam.
And the proceedings of and the departmental proceedings number 1 of 2024 initiated against petitioner shall remain stayed till the next date of listing. Next paragraph, petitioner shall produce a certified copy of the order before the Subordinate Police District Karbi Anglong within bracket respond number 5 to bring the order to the notice of the said authority. List after 4 weeks.
Obliged, your lordship.
Item 7.
So where the petitioner was working as a labor under the Kaladuga PWS scheme under the Jal Jeevan Mission, which falls under the Public Health
Just now, man.
Engineering Department of the State of Assam, lordship.
Just now. Okay, issuing a notice at this stage.
Lordship, I just wanted to point out, Lordship, in the second line of the synopsis, Lordship.
Yes.
Third line, Lordship. As per the mission, the post of Jal Mitra is required to be appointed on the suggestion of user committee of concerned panchayat. So, Lordship, that is the body that will engage, that can engage, Lordship, and that has not been implemented in this petition.
Lordship, but we have on page 14, lordship, we have annexed the certificate, lordship. On page 14, lordship, we have annexed the certificate. He has been training, lordship,
and
from 2014, lordship.
Page 14.
Yes, lordship, annexed.
Nobody is right if you, Mr. Bhattakur is right if you are saying that the user committee will take a decision, then you will have to impeach them. So they can empty them, otherwise your representation will be defective. Have you said the current counsel for the petitioner? Next paragraph is I what I put on it. Standing counsel for the PHE has referred to the synopsis of this writ petition and has submitted that the it is the case of the petitioner that the post of Jal Mitra is required to be appointed on the suggestion of the users committee of the concerned panchayat. Accordingly, but this users committee is nothing. It doesn't exist otherwise.
Lordship, it is the association of people who are availing the scheme, Lordship. So they have been empowered to engage these Jal Mitras, Lordship.
Okay, so they have a legal sanctity.
Lordship, and I have a copy of guidelines also, Lordship. If
Just show me, because I don't know about this.
Lordship, on the third page, on the top part, selection of operators volunteers. New operators volunteers of PWSS shall be engaged by water users committee.
This one. Next, accordingly, the land counsel for the petitioner prays for and is granted liberty to impede the water users, after that apostrophe, committee concerned as respondent number six by providing a specially typed out cost title to the UJ civil rule pending section, who on receipt of the same shall carry out the necessary corrections in the central registry, and thereafter list the matter in the motion columns. As and when such corrections are done. Okay. Okay. Go back in.
Item 8.
This is the second writ petition, Lordship. Earlier petitioner also received this honorable court by filing the writ petition, Lordship, regarding the release of arrear amount as well as sanction, Lordship. In the year 2020, petitioners retired from service till date. He has not getting any pension, Lordship. Nothing.
But Mr. ABT Hawk, learned counsel for the petitioner.
For 1, 2,
A.
and 5.
Tarukdar, learned, as well as Ms. A. Tarukdar, learned government advocate appearing for respondent number
1, 2, and 5, Lordship.
1, 2, and 5. And Mr. B. Chakravarti, learned standing counsel for respondent number 6. And Mr. Albert Pujari, learned standing counsel for the finance department, representing respondent number 3. In this repetition is projected that despite order dated 6/12, that where is that order?
Order page 29, Lordship, page 30. There is a direction to file representation, Lordship. Accordingly, we have prepared representation before the authority, Lordship. Thereafter,
But Mr. Hawk, then you have to satisfy the court. There can't be a repetitive read. Once you got an order,
yes,
you should have filed a contempt.
this is 2021, Lordship, not 24, Lordship.
No, I understand, but what can be done? There cannot be a repetitive writ. There are judgments of Supreme Court and also authored by me that there can't be a repetitive writs.
Regarding contempt, Lordship, delay is there accordingly.
I understand, but there's a bar for repetitive rates.
Thereafter, some communication is there, Lordship. Subsequent development is there after this direction.
So how can you satisfy us to take it up on day after tomorrow? We prevail with the case law on the point because repetitive rates can't be issued. That is one part. Second part is that your claim dates long back to 2014,
Yes, Lordship.
non-deciduous salary.
Yes, Lordship. If I withdraw this writ petition, I prepared a contempt petition.
And why we imputed responsible for chief judicial magistrate? Chief judicial magistrate has
He was
no relationship with your engagement.
the peon of public prosecutor office under the.
So you're not under the establishment of the chief judicial magistrate.
Presently, nothing to do.
Then you say that when the documents you say that you are attached to the government leader.
Government leader.
Government leader has got nothing to do with chief judicial magistrate.
Some communication is there according to.
No, you see someone may write. Someone may write representation for you. Doesn't make you an employee of that the authority. It is your case that you are the peon of government leader. Chief judicial magistrate got nothing to do with your appointment. The chief judicial magistrate was not your appointing authority.
Some communication is there according to.
No, communication is something else. By virtue of the post I am holding, so many people come to me for some certificate or something, and I issue it randomly. So everybody can't, what do you call, if they are aggrieved, they can't make me a respondent saying that this is Surana had given a recommendation. Somebody says that I am a good man, I give a certificate that yes, he is a good man. And he goes to an office to get an employment. Doesn't make me his appointing authority. Fighter, you be prepared on that. Whether a repetitive writ can be issued under the facts and circumstances of the case is issued to be on which the counsel for the petitioner shall address the court. Next one. The court also finds that There's nothing on record to show that the Chief Judicial Magistrate, Dima Hasao, within bracket respondent number 4, is the appointing authority for the petitioner. So therefore, the learned counsel for the petitioner shall also address the court on the as to whether the respondent number 4 is a proper and necessary party in the writ petition. Next, list on day after tomorrow, Mr. Hawk. List on 7/6/2024 in the motion column. Be prepared with the case law.
Lordship.
Item 9.
Deeply obliged, Lordship.
You'll have to do the research. I'll not do the research.
Lordship.
Correct?
I'll apply the court, Lordship. Deeply obliged, Lordship.
Yes.
Lordship, this is again dismissal lordship. The appeal has also been rejected. So lordship may issue notice at this stage. Lordship.
The question is, you're permitted to jump from here to here.
Sometime lordship.
Sometimes. Okay.
Yeah, the allegation is that lordship I demanded, but it from the deposition of the witnesses, lordship will see that money was demanded by one constable Hirok Jyoti and the SI Mukunda Upadhyay was the IO. I was never connected with this investigation. Lordship. Anyway, lordship
Take
is
notice.
at this stage. And even
You have filed an appeal also?
that has been rejected.
Rejected, okay. The Mr. B. Chakravarti and counsel for the petitioner and Ms. A. Talgar and government advocate appearing for the
All respondents.
for the respondents, all the respondents. Next paragraph. The order of dismissal from service and the consequential rejection of the appeal is held in this writ petition filed under Article 226 of the Constitution of India. You should notice a motion to turn over in 4 weeks. Requisite extra copies of the writ petition is served on the learned government advocate within 2 days. Next, list on so and so. Do we need the record of proceedings? No.
Lordship.
Do we need that? No.
After lordship issue rule is been issued, then lordship will call for law.
Deeply obliged, Lordship.
Item 10.
My lord, petitioner, my lord, BSA constable, my lord, was discussed by the imperial order that you will also find page 51, my lord.
Okay. Heard Mr. M.A. Islam, Grand Counsel for the petitioner. Next, the discharge of the petitioner from service on medical ground is by order dated 14/5/2024 is assailed in this writ petition filed under Article 226 of the Constitution of India. Union of India, who's there? Ms. Vijita Sharma. Ms. Vijita Sharma, learned. CEC accepts notice on behalf of the all the respondents. Please show her the cause title.
All the respondents.
Show her. All the respondents.
Yes, Lordship. All.
Extra copies of the writ petition will be served on her in the course of the day. Next paragraph.
In 9 to 12.
We give a date after 5 weeks. We give a date after 5 weeks.
26/7.
Return of essential list on so.
All right.
Item 12.
Lordship. What's the matter of non-payment of pending arrears lordship from 1/4/2010 to 30/11/2018 lordship, and amount to 4,500 as per official order dated 25/1/2012 lordship. Annexure page 19, and from 1/12/2018 to 28/2/2022 lordship, as per official order dated 14/12/2021. Annexure page 35 to 50 lordship. And petitioner have submitted representation for released the pending arrears, Lordship, on 27/2/2024. Annexure Z, page 46 to 51, Lordship.
Now, what has happened to your contempt petition?
Lordship, only appointed, Lordship. Only appointed, Lordship.
Pardon me?
In the contempt petition, I have appointed by the respondent authority on 14/12/2021, Lordship. And a similar matter will be disposed of, Lordship. As disposed of.
No, no, what has happened to your contempt petition number 11 of 2018? Where is the order passed there? Final order?
Final, Lordship. Page 35, Lordship. I was appointed by the respondent authority. The liberty was given to the Bolram Google, Lordship. Silence the face order, Lordship. In page number 35, Lordship, CL number 8, my name is reflected, Lordship.
Mr.
GG Google, Lordship.
GG Govind and Counsel for the petitioner.
Malad,
Mr. P. Azarika and Mr. Stanikos for the PNRD. And Mr. Arbor Physics and Mr. Stanikos for the Finance Department. Next, please.
Malad, there's one aspect I would like to bring to your kind notice, Malad. Malad, the same counsel had earlier filed similar writ petitions seeking his arrear salary. And Malad, coordinate benches have passed appropriate orders. I would just like to bring to your kind notice one of the orders. His representation at page 49, the coordinate benches have asked the commissioner, directed the commissioner to dispose of the representation, which is at page 49, Malad, in this writ petition. Just speaking order. Similar issue. Counsel again. Petition proposal.
In this case, representation will not be a adequate way to direct salary. Have you ever seen by representation the government has allowed the disbursement of salary? In your experience, no, it's okay, but in your experience as a counsel, either this side or that side, have you an experience of representation being submitted and the area salary being released by the government of Assam?
In the case of Panchayat elected members, similar cases, my lord, they were given only out of the 60 months, that is 5 years of their tenure, they were initially paid only 12 months. So remaining 43 months, similar cases which were pending. Later on, my lord, the arrears were released in 3 installments. My lord. Out of that first installment has already been released to the concerned petitioners, my lord, post their representation.
So can we dispose of by saying that within 3 months you'll release?
After verification of the service.
Give a timeline. At your, we will record your undertaking and then dispose it off.
My lord, may dispose it of in the lines of the same order?
No. Shadi doesn't come. In Panchayat, can you tell us what is the time when the salary was paid to the elected Panchayat members? Was it around elections?
That was after their retirement, my lord.
After the retirement?
After the retirement, they filed the.
No, we don't want Mr. Gogoi to retire and then get his salary.
In fact, my lord, he was only relying on this.
No. Salaries is never by representation. Giving non-payment of. Now, in this order, please tell us, you give a phone call to your authorities and come back at 2 o'clock as to whether pursuant to this order of 23/2024, you are now in June. Has this salary been released? You take a call and come back at 2 o'clock. You find out whether this order has been complied with. Take back this copy.
Item 13.
After some time. Order to the legal.
Lordship, in this matter, there is in two places there is a tapestry error, Lordship. The date, the year, Lordship, it ought to have been 2013. Lordship, in the petition paragraph 2, it has been written as 2023, Lordship, and in the synopsis also. Lordship, I pray that I may be allowed to correct this.
But 2013, you have to satisfy whether we issue it. In 2013 matter, we are not inclined to issue it when the judicial interest died in 2013.
Lordship, they have rejected my case in 2022, Lordship.
Still, the principal time will apply.
2013, Lordship. The
So
person
that's
died.
okay. Once he's admitting it, we are not.
And
We've got
Lordship,
nothing to say. But 2013, even if it is rejected, can't be considered in view of the Supreme Court judgments subsequently.
Lordship.
We'll be dismissing our petition. 2013 compassionate appointment cannot be made now.
Lordship, they were voted TRA, Lordship.
they have rejected on the ground of there is no availability of post, Lordship. Vacancy.
Correct. The vacancy will have to be under the OM. It will be the vacancy of the year when the person had died. We don't expect 2013 post to be kept vacant by the authorities just for you.
Lordship,
2013 post will not be available now.
as per the OM of 2015, Lordship, there is a provision of if there is no vacancy available in
Person died in 2013, Lordship. How can the 20?
No. It will be applied when you consider that. It's
they
well
have
settled.
considered Lordship in the year 2022, Lordship.
Still, you can't be considered now. Mr. S. Sutradhar, counsel for the petitioner, as well as Ms. A. Talukdar, learned government advocate appearing for respondent number
2 and 3, Lordship.
2 and 3. Mr. Anupadhyay, learned standing counsel for the irrigation department, representing
and
respondent number 1 and
1, 4 and 5.
1, 4 and 5. Next paragraph. In brief, the case of the petitioner is that his father namely late Pradeep Sutia, died in harness on 1/8/2013 while working as Khalasi, which is a grade 4 post under the executive engineer, Jorhat Division, in bracket irrigation. Full stop. The petitioner applied for appointment on compassionate ground by on 8/10/2013. Full stop. It is projected that after undue delay, the district level committee in its meeting held on 21/3/2022 examined the claim of the petitioner, and the same was rejected on the ground that there was lack of vacancy. Full stop. Next part. The petitioner is also projected that on an earlier occasion, the DLC in its meeting held on 26/6/2014 had rejected the application of the petitioner on the ground that he had a better financial position. Full stop. Accordingly, next paragraph. The learned counsel for the petitioner relies on the OM dated 1/6/2015, and it is submitted that if there was no vacancy in a particular department, the vacancies available in the other departments ought to have been considered, and the petitioner's claim for appointment on compassionate ground ought to have been considered in light of OM dated 1/6/2015. So accordingly, it is submitted that the rejection of the candidature of the petitioner was
26
not sustainable. Next paragraph. This Where is the earlier 2014 order?
That is not with me, Lordship.
It's not, okay.
At page 20, the latest DLC, Lordship. 21/3/2000.
Yes.
And page 22 is the relevant portion, Lordship. Page 22, point number
Point
6.
22. Next, in connection with the relief claimed by the petitioner in this petition, the learned government advocate has placed reliance on the decision of the Supreme Court of India in the case of
Debabrata Tiwari Lordship.
versus Debabrata Tiwari. The project that the inordinate delay, even on part of the state to consider the application, would make the consideration would disentitle the petitioner for any consideration of appointment on compassionate ground. Full stop. Next para. In light of the observations made by the Supreme Court of India in paragraph, what is it? What are those paragraphs? 7 point? Mr. Upadhyay? You have the paragraphs?
Lordship, it was
7 point.
the state of Bengal was a Jwari, and the paragraph was
Para 7.4 and so on. So the paragraph. When the Supreme Court of India had observed as follows, those two paragraphs. In view of above, we find that as the father of the petitioner has died 11 years ago, the said decision would be squarely applicable in the case of the petitioner. Next paragraph. Moreover, as per principle 10 of the OM dated 1/6/2015, read with
$7.5.
7.5 Lordship.
7.4 and 7.5.
No.
In view.
$7.5 Lordship.
And in view of subparagraph 10 of paragraph 7 of the judgment of this court in the case of Achyut Ranjan Das and others versus State of Assam and others within bracket 2006, that is 2006 within bracket 4 GLT 674. The court is of the considered opinion that the name of the petitioner would require no further consideration and must be understood to have spent their force. Next paragraph. The next paragraph. The learned counsel for the petitioner has placed reliance on the judgment of this court in the case of Kabir Ahmed PABIR Ahmed AHMED Chaudhary CHOUDHURY versus State of Assam and others, WPC 243 of 2020, decided on 10/8/2022. To stop. Next one. In light of the judgment of the Supreme Court of India in the case of Devrata Tiwari within bracket Supra, the court is inclined to follow the decision of the Supreme Court of India in the case of Devrata Tiwari within bracket Supra. And in light of the observations made therein, the judgment of the judgment and order of this court in the case of Kabir Ahmed Chaudhary would not have persuasive value over the decision of the Supreme Court of India. Accordingly, this petition stands dismissed.
Other lordship.
Deputy obliged lordship.
Item 14.
The petitioner
Just a
pursuant to
moment.
the
Just
advertisement.
a moment.
Pursuant to an advertisement, he was selected, Malad Prize, for the post of Gao Pradhan. It is Gao Buddha actually. Page 33, your lordship will can see. This is the selection,
You should notice at this date.
but the impugn order has to be stayed, my lord, and because your lordship will kindly see the
Where is
SP
that order?
order
Which
is
page?
at page 50. Because this has not taken the subsequent order. I'll just place, my lord, one order, may I just page 41.
No, but the cancellation is.
Page 41, your lordship will kindly see.
41.
Yes.
Because there is an allegation against you that
Yes.
you are.
Yes, subsequently it has been
Antisocial.
cleared. Subsequently, it has been cleared. I'm showing the documents. Your lordship will kindly bear with
Yes.
me for 5 minutes.
Yes.
This is a pursuant to the letter written by the additional deputy commissioner. He has, this is a letter from the superintendent of police, last sentence, sir. But he is involved in antisocial brokers activities at Dhing. Lordship got it, ma'am. Then subsequently, my lord, ADC requested additional superintendent of police to details of petitioner relating to antisocial. That is at page 43. Page 42, second
Yes.
paragraph.
Yes.
Hence, you are requested to furnish detail of the matter and relevant copy of case records, documents, etc., if any, along with specific comments on this regard. That is relating to that. Then thereafter, SP writes on page 44. Nothing adverse written. Page 44 and found correct. Nothing adverse written against him as per report of the inquiry officer. The true copies of the police report from the concerned PS, etc., are enclosed herewith. Subsequently, my lord, it is clarified, but he has stuck to that for earlier order, earlier report.
Yes.
So he has.
Will stay then.
Otherwise, there is a notification dated 1/4/2024. This is for violation.
Where is that?
Appeal may will file against that.
No, termination, what you call his termination in this way, it's not an appealable order.
Lordship, this has been clarified, Lordship, in a division bench, Lordship. Selection and appointment, Lordship.
It's not selection, my lord. It's relating to cancellation.
We show a copy to Mr. Das.
That is relating to selection process, my lord. But this is here, it is cancelled.
No? Initially selected, thereafter cancelled.
And thereafter cancelled on arbitrarily, my lord.
So once an appeal is provided for,
Lordship.
This is regarding cancellation, my lord. My lord, regarding there is no selection, my lord. Selection is all right, my lord. I am not agree by that. Then thereafter it has been cancelled on wrong footing, my lord, on the face of the record. My lord, if I'm not wrong, my lord, that notification should be regarding selection process. My lord, if I'm agreed, I'll have to go to the appeal.
No, selection, it says three things. Just show it, Mr. Gupta. It says three things.
Suspension and dismissal, appointment, suspension and
Suspension and
dismissal.
dismissal.
That is different thing, my lord.
That's otherwise.
This is not regarding appointment, my lord. My appointment has been cancelled. I have not been suspended or dismissed from the thing. Appointment has been cancelled during police verification on totally wrong footing, my lord. Where will this petitioner go? Okay. Government advocate just submits, my lord, I think on totally wrong footing, my lord.
Division bench judgment, it has been clarified that appointment and selection of both are interchangeable.
Yes, appointment and
Initially, he has been
selection, this is
selected.
different thing, my lord.
That's it. That's it. Read appeal number 227 of 2022.
Do you have a copy?
That's it. Yes.
Okay.
$22.
Read appeal 227, 22. Page 7. Amyo Kumar Das. That's it.
Amyo Kumar Kalita.
Kalita, sorry. 227.
But this issue has to be examined, Mr. Dutta.
That's it.
In this case, he was not suspended
No,
or terminated.
That's it.
He was appointed and the appointment order was cancelled. Therefore, the appointment never took place.
That's it.
Appointment order is not agreed by, Mr. Das is correctly saying, is not agreed by the order of appointment. He has been, it is in his favor.
Not being appointed as a ground
No, but it has been cancelled. Cancellation,
selection.
whether this cancellation will come within the meaning of dismissal, I don't think so. You can dismiss only someone who is holding a post. You can't dismiss someone who is not holding a post.
That's it. As per my understanding, he has agreed by being not appointed as a ground.
No.
That's why
No,
it's
it's not a case of selection. It's neither a case of selection nor appointment.
That's it.
You see, let us assume that A and B are two people.
That's it.
A was appointed. So B is aggrieved and he comes under 162C. But in this case, he is appointed. But his appointment order is cancelled. It's neither appointment nor suspension, nor it is termination.
In the writ appeal, my lord, he was appointed, then thereafter dismissed. It's a totally different case placed before you, lordship.
We should examine it. Mr. B.D. Raslan as senior counsel, assisted by Mr. D. Kalita, counsel for the petitioner. Also heard. For revenue, okay, Mr. S. Datta, and it's technically for the revenue department, except representing respondent numbers one.
Correspondent 2, 3, 4, and 5. Lordship.
One. And Ms. A. Talukdar, and government advocate appearing for respondent numbers 2 to 5. Next, brother. In brief, we case of the petitioner is that pursuant to an advertisement dated 8/1/2020, the petitioner applied in the selection process for appointment of it is Gaon Buran or Gaon Pradhan now? Gaon Pradhan of number 1 Dhing town under Dhing revenue circle. Where is your selection?
Page 36.
36.
7.
And accordingly by according to the name of the petitioner appeared in the list of selected candidates against the lot of the village under Nagaon Sadar Revenue Circle.
Dhing revenue cycle. Page 36.
36. Okay, Dhing Revenue Circle.
Serial number 7. 1 Dhing town, Priyaranjan Das, son of so and so. Serial number 7. Under Dhing revenue cycle. Yes.
Which was published by the selection committee pursuant to minutes of meeting held on 19 September 2022.
July. Yes, yes.
Next, brother.
1999.
The criminal antecedents of the petitioner was inquired. And as per the report of the Superintendent of Police Nagaon, dated 22/12/2022, he was found to be involved in antisocial brokers activity in Dhing area. Thereafter, by a letter dated 15/3/2023, the additional Deputy Commissioner Nagaon requested the additional Superintendent of Police within bracket DSB bracket close Nagaon for furnishing details of the matter and relevant copy of the case records, documents, etc. Full stop. In response thereto, the Superintendent of Police by a letter dated 29/3/2023 informed the additional Deputy Commissioner within bracket R bracket close Nagaon that the personal verification report of the petitioner was found correct and there was nothing adverse written against him as per report of the inquiry officer. And accordingly, the revenue officer, Dhing Revenue Circle, by a letter dated 25/7/2023, informed the additional Deputy Commissioner within bracket Revenue that the There is no record of any case or any material against any material regarding involvement of the petitioner in broker activities. Post stop. Nonetheless, the District Commissioner, Nagaon, by an order dated 22/3/2024, cancelled the provisional selection list of the petitioner. Full stop. Next paragraph, agreed by the aggrieved petitioner has approached this court by filing this petition under Article 226 of the Constitution of India. Next paragraph. The learned standing counsel for the PRD department,
Revenue Department.
Revenue Department, has produced a copy of notification dated 1/2/2024. The project, issued by the Revenue and Disaster Management Department. Disaster Management within bracket LA and A bracket close department. The project that an appeal under appeal against the order of appointment, suspension and dismissal of a Gaon Pradhan by the District Commissioner is an appealable order under section 162-C of the executive instructions under the Assam Land Revenue Regulation, Assam Land and Revenue Regulation 1886. Full stop. Relying on the decision of the division bench of this court in the case of AMIYA, Kumar Kalita and others versus State of Assam and others, W827 of 2022, decided by order dated 30/7/2022. It is submitted that the word selection and appointment are interchangeable as held by this court, and therefore, notwithstanding that the appointment of the selection of the petitioner was cancelled, but it relates to a dispute regarding selection of the petitioner and therefore appealable. Next paragraph. The issue as to whether the cancellation of appointment order amounts to either appeal against, whether it could be covered by appeal against the order of appointment, or it could be an appeal, or it can be termed to be an appealable order against dismissal of a Gaon Pradhan, is an issue which requires determination by this court. Next, accordingly, the court is inclined to issue notice returnable determined by the court because of the fact that the petitioner is not aggrieved by his selection. And the other comma, he is aggrieved by the cancellation of his selection. Accordingly, issue notice returnable. How much time, Mr. Datta?
This Deputy Commissioner will take instruction, Lordship.
Lordship, 4 weeks time. 4 weeks time, Lordship.
4 weeks. No, we are asking you because we are staying it, therefore we are asking you.
Lordship, in that case, Lordship, 10 days, Lordship.
10 days, okay. Returnable on we make it 2 weeks from today.
2 weeks, yes.
Today is the 5th, we make it
Fifth.
19th. Returnable on 19th, 6/2024. As already respondents are represented, offense of formal notice is dispensed with. However, requisite extra copies of the writ petition is served on the Honored State and Departmental Counsel in course of the day. Next paragraph. In view of the nature of issue involved in this writ petition and taking into consideration the fact that the Superintendent of Police Nagaon has provided written instructions to the Additional Deputy Commissioner that there is no adverse remark against the petitioner. The observation made in the impugn order dated 22/3/2024 that the petitioner is involved in antisocial broking activity is found to be contrary to the report of the Superintendent of Police Nagaon. First of all, according to the operation of the impugn order number NRK *02/2021 Part 5 PT-Roman 5 dated 22/3/2024 passed by the District Commissioner Nagaon shall remain stayed till the next date of this.
In respect of the petitioner.
Yes, and is this only for you? Because no one else.
Subject to what your lordship may say, because I think this is a mistake committed by the deputy commissioner, overlooking the subsequent. Therefore, there are no bar for representation. Consideration.
No, we don't say that because otherwise there will be again difficulties.
Matter can be sorted out after 10 days if they bring admission.
Because if we permit parallel adjudication now.
That's all right. Then after 10 days, because he has overlooked that subsequent clarification given by the SP.
We don't know why this.
Let it come after 10 days.
We are returning to the judgment and this notification. Yes. No. We'll take a break and come back. Old pension or new pension, then we issue notice then. Okay, I thought it was an issue of regularization.
Not regulation, but the issue of old pension issuance scheme, and the ACB has already done it. So for if your lordship go through that order, I have.
It's okay, I'm issuing a notice right now.
Yes. We have arranged all those things.
Mr. S. Mishra and counsel for the petitioner, as well as Mr. K.V. Pathak and standing counsel for the APDCL. We are appealing for all the respondents.
All the respondents.
For the respondents. ACB respond, sorry, for the respondents. Next one. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned counsel for the respondents in course of the day. Next para. The pendency of the writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner and pass appropriate orders. This after 4 weeks.
Item 17.
Wait, the lordship. Lordship, the petitioner was posted to Guwahati, frontier headquarters of SSB on 30/12/2021, my lord. And within 68 days, my lord, he was again posted from Guwahati to Devnagar, my lord. When he was posted to Guwahati, my lord, he was posted on own request, my lord, without traveling time allowance and joining time, my lord. And thereafter, within 68 days, my lord, he was posted from here to Devnagar, my lord.
And he has represented that this posting should be treated as a public interest posting, my lord, so that he can get the benefit of TTA and JT, my lord. But that representation has been rejected, my lord. That is page number 33, my lord, next 11.
We will issue a notice. Heard Mr. V. Kumar, counsel for the petitioner. You are appearing for all the respondents?
Well,
And Mr. UK Goswami and CEC appearing for all the respondents. Next, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on CGC in course of the day. Next, list after 4 weeks.
My lord. DPL lodge.
Item 18.
May please, my lord.
Issue notice here.
Perhaps there is some. My lord, I seek sincere apology from this honorable court, my lord. There is a problem with the annexure, my lord, one of the annexure, my lord. I seek liberty to do the corrections.
On the prayer made by Mr. P.R. Sharma and counsel for the petitioner, the petitioners is permitted to make
Let him file an amended copy of the petition, your lordship, because one of the annexures is perhaps
one of the
wrongly tagged.
They can do it here. To make necessary. Corrections in the you want to replace it?
My lord,
Or you want to add?
My lord, one annexure, my lord.
You want to add?
Yes, my lord. Replace and add the correct.
To place on record the correct annexure by substituting the annexure number
4, my lord.
Annexure 4 to this petition. The corrections are permitted to be done in the presence of the AOJ civil pending section. If the matter be listed in the motion column after such corrections are done.
Supply item 57.
Oblige. My lord, should permit me to seek an apology, my lord. On the synopsis, I have made a mistake with error. The last part of the synopsis was not supposed to be there. So that for today, lordship should ignore, my lord. On the synopsis, my lord. What was to be from the word therefore onwards, my lord. It has come from some other petition. I was seeking challenging the transfer, the promotion. What has happened is this petitioner is serving in the Central Reserve Police Force. And my lord, she has remained unmarried throughout her life. Her 2 sisters married to take care of her parents, my lord. Now, my lord, when she was transferred to Guwahati in 2020, staying with her mother, she came to know that her mother was suffering from Alzheimer's disease and cerebral atrophy from November 2023, my lord. I have given the medical documents. I would refer to that. Now, lordships may kindly have page 17, my lord. Page 17. Even before the summer chain transfer, which is a rotational transfer, routine transfer, a request was made to the authorities that this is my position. An extension of 1 year would suffice. I'll either make arrangements for my mother or that woman. Thereafter, at page 18, annexure 2, lordship would find on February 19, 2024, my lord, I was subjected to the summer chain transfer being transferred out from here to West Bengal, where 232 battalion stands. Lordship has page 18, my lord. Immediately thereafter, on 24 to 2024, with all my
Transferred to
mother's
which place? You're
my lord,
transferred to?
I am transferred to 232 battalion, page 18, Lordship will find.
Where is it located?
West Bengal.
It's West Bengal, my lord.
No, which place in West
My
Bengal?
lord, they say it is the LWE area, the battalion headquarters stands at a particular place, and the units, what we call the units, my lord, from A to G units are there. These units are kept at the locations wherever there are requirements of the. So these battalions.
General idea of location is not there.
No, it is the commandant who would allot a particular company.
No,
What they call a company.
For example, I am saying that let us say that there is a particular area, we say we call it Nagaon region, or we call it Bangaigaon region. Any such locations are available? No.
My lord, no. Here, what they do is they have a zone first. Now we fall in the northeast zone as per the CRPF. Under the northeast zone, we have 4 sectors. Under the 4 sectors, we have different group centers. Each group center would have different battalions. Now, one battalion having a headquarters at Guwahati may have a company serving at Maharashtra.
Okay.
Under a company commander. So here at page 18, it's 232 Mahila battalion, which is now headquarters located at West Bengal.
Where is the policy? Because of the ailment of your mother, can you be can your transfer be stopped?
Madam, I have just submitted a copy, an additional affidavit, madam, I have filed today morning. It was called for.
Yes.
There, Lordship will find it page 38. Annexure 1, Lordship finds.
Yes.
This is 8th of October 2018. And Lordship would have paragraph 3. With the enactment of the Rights of Persons with Disabilities Act 2016 on April 17, 2017, the following instructions are issued in supersession of the above mentioned OMs of event number dated so-and-so, 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 with regard to the eligibility of seeking exemption from routine exercise of transfer or rotational transfer. A government employee who is a caregiver of a dependent daughter, son, parents, spouse, brother, sister with specified disability as certified by the certifying authority as a person with benchmark disability as defined under Section 2 of the Rights of Person with Disabilities Act may be exempted from the routine exercise of transfer, rotational transfer subject to the administrative constraints. Thereafter, Lordship would like to have page 39, subclause 3.
Where is this Alzheimer covered?
Alzheimer would be covered if Lordship has the act. Look.
Alzheimer is specifically not mentioned in this.
That is what I was trying to show, my lord. The act says so, my lord. The act, although it does not refer to the
Right to persons with disability act.
My lord.
Right to persons with disability act. No, R, right to persons. Right, R. Not in P. No, R.
Your Lordship may like to have the schedule.
That should be good. Oh, it will be persons with disability. P. It will be persons with disability. Right of Persons with Disabilities Act. Right of Persons with Disabilities Act.
2016.
Section.
My lordship will have the schedule, my lord. At the end, my lord, after section 102, the schedule is there. Their lordship may like to have number 3, serial number 3. Mental behavior, lordship. I'm sorry.
No, not this. Right of Persons Act. Right of Persons with Disabilities Act. 2016. Right of Persons with Disabilities Act. Because this 102.
My lord.
Special disability.
Yes.
Is leprosy cured person, so and so, dwarfism, cerebral palsy, muscular atrophy, acid attack victim.
Lordship is having it.
This is a schedule.
Schedule.
Specified
Yes,
disability.
lordship will have serial number 3. Mental behavior part. This is a mental behavior. Man. Physical disability is 1A, 1 capital A. Then there is capital B.
1 capital A.
Then
one capital B is visual impairment.
C is hearing impairment.
C is hearing.
D is speech and language.
Yes.
2 is intellectual disability.
Yes.
Then 3 is mental behavior.
Yes.
Mental illness means a substantial disorder of thinking, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life, but does not include retardation. So Alzheimer's and the cerebral atrophy. The GMCH, my lord, has been treating my mother. And this office memorandum at clause 3 and clause 2 includes mental illness as defined in the act, in the schedule.
But if the word is not used, it will be very difficult to add a word.
My lord, we find mental illness is there with substantial disorder of memory. Now, if my medical certificate, since it has started in November 2023, it was detected. It will take some days for me even to acquire a certificate of disability. Now, that lordship, if lordship has the page 33 and 34 of my writ petition, page 31, 33, and 34. Because after all, if this is a transfer, given an opportunity, if they have their own medical board, they can take my mother there. If I am the caregiver, office memorandum says the caregiver will be given an exemption from routine transfer. If this is a routine transfer, then that exemption could have been considered for me. If it is a case where I am the only person who can go and stand in 232 battalion without which the CRPF or the 232 battalion suffers, perhaps it will be administrative exigency. But given this situation with the office memorandum and the act, Our case is that that angle has not been taken into consideration. Even the rejection orders will show that a board of officer had rejected it summarily, and therefore my second appeal, which went to the DIG with a recommendation that I should be retained, looking at the condition of my mother, was rejected only on that ground. Board of officers has already rejected. That lordship would find, which was given to me on 29/5, 29/5, issued on 27/5, at page 29, lordship will find. At page 29, madam.
Where is your transfer order?
My initial transfer order is at page 18, madam. And it's serial number 1. I have served for 27 years, my lord, not a whisper any day that I will not be like to transfer to this place or that place. My father expired in 2018. Mother is now having troubles in 2023. I am unmarried. I remained unmarried for my parents. There's a statement in the repetition on affidavit. Because my sisters got married off. I'm the only serving person. I needed to take care of them.
Yes.
Lordship, first of all, Lordship, that the statement that she is suffering from November 22, that is not correct. Her own application shows that her mother, page 25, and the original also, Lordship, that her mother is suffering from this forgetfulness or Alzheimer for last 10 years, Lordship. So, and more so, Lordship, this is a summer chain transfer, and it is through a computerized system, Lordship, then system for annual transfer of her software. And as per that, Lordship, this was done, Lordship, and she had already completed her tenure here, Lordship. And the 1-year exemption, Lordship, I'm sorry to say, Lordship, but in such cases, there is no possibility that patient recover from after 1 year, Lordship. Then somehow she has to make a balance, Lordship. She cannot say that after 1 year situation will be better, Lordship, because her mother is suffering, Lordship. In that case, Lordship, and I already stated that her tenure is complete, Lordship. We have to arrange. There is a system that for preferences, and one can submit their representation, but preferences has to be filled considering all the condition, Lordship. Whether it is the board is there and board decided whether it could be given to or not, Lordship. But here, Lordship, her mother is suffering from 10 years, and it's not that it's a very situation which just now arises, and 1 year also there is no possibility that the situation will be better, Lordship, and most of the cases it worsen, in fact, Lordship. So this perhaps is not a better case to consider her prayer, because and her personal reason of marrying, not marrying is a different issue, Lordship, but here in service, Lordship, this is a defense, and we have to take care of everything, Lordship. Her tenure is complete, Lordship. One who is already there, they also have the right to come to other places, Lordship. We cannot retain her for long, Lordship.
Then why we should not quash this office memorandum of 8/10/2018?
Lordship, in fact, the transfer was as per
No,
standing.
not that. You see, every person can have some disease or the other.
Yes.
Then why we should not quash this office memorandum of 8/10/2018, although there is no challenge?
What is his mother's problem that is not included in this office memorandum? And the transfer is as per standing order 4 of 22, Lordship. And as there is a provision for certain consideration, but this is possibly not included, Lordship. Mental illness, and this is also not very. It's
in the office memorandum. It is there in the office memorandum.
only mental illness and mental retardation, but here it is a forgetfulness only.
No.
Alzheimer, forgetfulness.
Alzheimer is a medical condition.
Medical condition is that, Lordship.
Mental condition. It worsens
Yes.
with the passage of time.
Yes, Lordship. That is what that 1 year exemption possibly in this case because she is suffering from 10 years and somehow she has to
Lordship would like to
see
page
that also,
34.
Lordship. Because she is for
latest
last
report of the doctor, which says that the patient is to be associated with an attendant for safety, patient not to be left alone.
see
And if
5
the
years
argument
she
is
is
that
here.
in 1 year it will be worsening and therefore let it worsen now, I would have little to say on that. That is not perhaps a situation which I have an answer to.
I'm not saying that I'm saying that the temporary arrangement will not do, Lordship.
That is what it said. Very prayer is for a 1 year retention, taking into consideration. Let them have a consideration of the mother. Let them take a medical evaluation of the mother at the CRPF hospital under their authorities. If my mother, if I have been transferred to a location where I can carry my mother in the situation she is.
She was here for last 5 years. Prior to that also, she had she was in another place, Lordship.
Yes,
So somehow she has to arrange.
In 27 years of service, my lord, I asked for 1 year retention. There are 15 I have stated, my lord. I was retained at Delhi from 97 to 2005. Then the 3-year term or 4-year term did not hamper them. They needed me there, they kept me there.
But Mr. Mazumdar,
My lord.
I think to either amend your writ petition or to file it afresh.
My lord.
The reason is that if you are if you are referring to the office memorandum and you are projecting that the specified condition as provided in the schedule is not included, then without that inclusion,
That mental illness is included.
no, in this office memorandum you are showing us an 8, 10, it's not there.
It is there, my lord. Mental illness is there.
Where is that?
My lord will find at paragraph 2.
Paragraph 2.
Serial number 6, Roman 6.
Mental illness.
Then lordship will have paragraph number 3.
Yes.
Roman 8.
Mental illness.
Mental illness, and mental illness here means a substantial disorder of thinking, mood, perception, orientation, or memory. It comes in.
We could follow.
The word Alzheimer as such may not have come in.
It's okay.
The transfer order was issued in February. I had made my representations due to the elections and everything. No relief order has been issued till now.
Mr. Counsel for the petitioner and Ms. B. Sharma, Learned CEC appearing for the respondents. Next paragraph. The petitioner is serving as head constable in the Central Reserve Police Force. And is presently under the Commandant, Group Center Amerigo, and is under order of transfer dated 19/2/2024, whereby she has been transferred to 232 within bracket Mahila, right? Bracket closed, battalion of CRPF to be given effect to after 15/5/2024, right?
Madam.
Next, madam. The case of the petitioner is that for last 10 years, her mother is suffering from Alzheimer's disease, ALZEIMER. Alzheimer's disease. Spelling is correct? ALZIMER.
Yes.
Alzheimer's disease, which according to the learned counsel for the petitioner is an illness relating to mental behavior, which is squarely covered by column 3 of the schedule relating to specified disability under the Rights of Persons with Disabilities Act, 2016. It is submitted that under the Rights of Persons with Disabilities Act, 2016, the petitioner being the caregiver of her mother is entitled to exemption from routine transfer, public rotational transfer in terms of OM dated 8/10/2018 issued by the Government of India, DOPT. So it is submitted that the petitioner had preferred a representation against the order of transfer, which was rejected. By order dated 27/5/2024.
Initially, there is another order of rejection.
Huh?
There is another order of rejection prior to that on 16/4/2024.
Okay, 16/4/2024. And
Thereafter, the DIG had recommended my case. And that is rejected on
thereafter, the DIG, CRPF recommended the case of the petitioner. First of, however, once again, a representation was rejected by an order dated 27/5/2024. And the petitioner was relieved.
Not relieved.
No, yes, you say so.
No, I was not relieved.
I'm reading it. See page 3. See page 3 first. Page 3 of a petition is so and so rejected and relieve the petitioner to transfer. That is what you say.
First, for page 3, course item.
Page 3.
My lord.
Not released.
Not relieved.
Not released. Yet to be released. Not released.
Okay.
Little,
You will never know where I start reading.
Oh,
Don't say relieved. So accordingly, the petitioner has filed this petition on Article 226 of the Constitution of India for directing the respondent, directing the Director General of CRPF, in bracket respondent 2, to consider the retention of the petitioner at the present place of posting for 1 year in terms of the office memorandum this doesn't say 1 year.
it will be exemption throughout. I am seeking a year.
Don't say that.
Administrative exigency
For 1
transfers
year.
can be there. Routine cannot be there. That's what it is.
Next paragraph. The learned CGC has vehemently opposed the admission of the writ petition, as well as she has opposed the prayer for interim relief on the ground that the nature of disease suffered by the mother of the petitioner is not specifically included in the schedule to the Rights of Persons with Disabilities Act, 2016. So moreover, it is submitted that as the mother of the petitioner is suffering for last 10 years, there is no possibility of a recovery within a year's time. And accordingly, it is submitted that as transfer is an incidence of service, petitioner shall have to accept the order of transfer.
Lordship, one more submission, Lordship. Alzheimer is not mentioned in any of the medical document. Only forgetfulness is written. Alzheimer is stated by the petitioner, but medical document 31, 32 is specifically mentioned only forgetfulness.
And the other one
Whether
is
that amounts to Alzheimer or not, that is also not there. And
cerebral atrophy.
cerebral atrophy, that is there. But Alzheimer word is not in the medical document.
You know what is cerebral atrophy? You're aware of it? No. I'll tell you. Cerebral atrophy is a mental condition where the brain mass of the brain shrinks. So there is a, you just check up. In the internet, you check up, you will find that is cerebral atrophy. There's two atrophy which occurs in the brain. One is a cerebral atrophy and one is a cerebral. Cerebral, CERE, one is cerebral, CELL. These two takes place together. Not only the brain mass shrinks, but the mass itself shrinks. There are two simultaneous things which are happening in the brain. And therefore, once a point is reached, dementia turns into Alzheimer. So both conditions I will find in the scanning report of brain when you have this forgetfulness, that is what is called dementia. And when dementia progresses, it converts into Alzheimer. During my free time, I do read medical books.
Just off the record, my lord.
Huh?
Just off the record.
the hurry, why I am before this honorable right because this matter. The mother has attempted self-harm twice.
No, that will happen because you see, then in
No,
a,
that
in a
is why
stage
there
of,
are no statements to such
in
effect.
a
I have
stage
not
of,
argued that.
in a stage of dementia, when
What
it comes
happens
to
is
near Alzheimer,
very
there are 4 stages which a patient suffers. Let me not give a lecture on the medical side, but there are 4 stages. It's a second stage of valence is and suicidal tendency is the third one in that stage. So let me not take the time of the bar members in lecturing in medical science.
It is enlightening. We get some glimpses of what we are getting a glimpse of what a person may suffer.
Uh, No, we've already stated that is not a specified disease, and the post-fight is also submitted that the medical documents produced with the petition does not refer to the specific ailment of Alzheimer. Next paragraph. Issue notice returnable on 2 weeks. Returnable on 21/6/2024. So requisite extra copies of the petition be served on the runner CEC in course of the day. Next paragraph. Yes. As the disease of Alzheimer is generally known as, is generally understood as a brain condition that causes a progressive decline in memory, thinking, learning, and organizational skills, and it gradually destroys memory. It privacy appears to the court that the said condition would constitute, would be covered by column 3 of the schedule relating to specified disability as provided under the Rights of Persons with Disabilities Act, 2016. Under such circumstances, the court is of the considered opinion that it would be an appropriate case to stay the operation of the transfer order. Where is that transfer order?
Page 18.
Transfer order.
3 persons only for the petition.
Transfer order number STC 2024 dated 19/2/2024 issued by the DIG within bracket ESTT full stop bracket close capital DTE. This is page 18. In respect of the petitioner, namely
Malati Devi.
no this. How do you write the name of the person? You write the number first.
They write the number first. Course number so and so.
Okay. You write sorry 9730 30021
HCGDM.
Give a dash, HC dash capital GD within bracket, MAH bracket close, multi MALATI, Devi. This page 18, right? Till the next date of listing, next paragraph. In the meanwhile, the respondent authorities, at their discretion, are permitted to have the medical condition of the mother of the petitioner examined at a medical facility of their choice. Full stop. Receipt of the medical report of the condition. If the said exercise is done, depending on the medical report received, it would be open to the competent respondent authorities to reconsider the representation of the petitioner dated. Where is that?
My last
What is the date?
My last representation
27,
was on
5,
27.
24.
27/5/2024. No, that was rejected. Which one? Which one was rejected?
23/4/2024 at page 27.
Okay, 23/2024 and obligor. Next one is?
That was the last representation. The earlier representation was.
No, which was rejected?
27/5.
27/5 was rejected. So 27/5 only one. 27/5/2024. By taking into account the entry at column number 3 of the schedule appended to the Rights of Persons with Disabilities Act, 2016. Next, the petitioner shall produce a certified copy of the order before the
Respondent number 3.
who is he?
I'm sorry, respondent number
4.
4.
Who is he?
Deputy Inspector General, Central Reserve Police Force, Group Center, Americoc.
Please repeat again so that you can write.
The Deputy Inspector General of Police, Central Reserve Police Force, Group Center, Americoc.
Within bracket, respondent number 4.
4.
Next para. On the prayer made by learned counsel for the petitioner, is permitted to make necessary correction in the synopsis as well as cost title of the of this petition, which shall be done in the presence of AOJ Criminal Appeal Section.
I'm obliged.
You give her a corrected copy.
I'll do. Obliged.
Time being item 12.
In pursuance of that High Court order passed by the coordinate bench, my lord had asked me to furnish the instructions as to what subsequent developments have taken place. I have a copy of the order passed by the commissioner.
It appears that they are taking steps. heard Mr. G. Gogol and counsel for the petitioner, as well as Mr. P. Hazarika and standing counsel for the PNRD and
P. Handy.
Mr. P. Handicap and standing counsel for the PNRD department and Mr. Alva Pujari and standing counsel for the finance department. Next para. The case of the petitioner is that he's working as a peon cum chowkidar as a casual worker without any break since when since his appointment order dated 21/1993 the monthly wages of the petitioner was fixed at rupees 4,500 per month. For those who were working prior to 31/3/2006. However, as the name of the petitioner was not included in the list, the petitioner and others had filed WPC 6209 of 2014, and this court by order dated, what is the date of order?
1/12/2014.
1/12/2014.
1/12/2014.
Directed the respondent authorities to pay fixed pay of rupees 4,500 to the rate petitioners, if found entitled to. Full stop. As the order was not complied with, the petitioner had filed a contempt petition, which was registered as contest C number 179 of 2015. However, as a speaking order dated 13/5/2015 was issued, the contempt petition was closed with liberty to the petitioners to challenge the speaking order dated 13/5/2015. Thereafter, the petitioners filed WPC 5223 of 2015, which was disposed of by an order dated 31/5/2017 with a direction to release the salary of the petitioners. Full stop. Owing to non-compliance, again a contempt petition, which was registered as Cont Case C11 of 2018 was filed. Full stop. Thereafter, the respondent authorities issued an order dated 14/12/2021 for release of monthly salary of the petitioner along with others. Full stop. However, the arrears salary of the petitioner from 1/4/2010 to 30/11/2018 and from 1/12/2018 to 28/2/2022 has not been released. That's this petition. Next paragraph. The learned standing counsel for the PNRD department has produced a copy of letter dated 6/5/2024 issued by the Commissioner, Panchayat and PNRD department, wherein referring to order dated 20/3/2024, passed in WPC 1593 of 2024, comma, the the supporting records along with the verification report has been called for to stop. Accordingly, it is submitted that as the petitioner has submitted a representation dated 27/2/2024, comma, the writ petition be disposed of with a direction to the Chief Executive Officer, comma, Lakhimpur, to dispose of the said representation first of
Well, there is one more representation at page 49,
49.
46 and 49, both. Two
Oh,
representations.
as well as 27 to add to the Chief Executive Officer Lakhimpur. Okay. Within bracket, respond number 10, as well as to the Commissioner, Panchayat and Rural Development Department, within bracket. Respond number 4. No, not 4, 6. Next, in view of the submissions made by the Learned Standing Council for the PNRD department, this representation stands closed with a direction to the Commissioner, Panchayat and Rural Development Department, within bracket, respondent number 6, to dispose of the representation of the petitioner dated 27/2/2024, preferably within a period of 6 weeks.
3
Period of
months.
6 weeks, from the date of receipt of a certified copy of the order, along with a copy of the writ petition. Next paragraph. If on inquiry, the petitioner is found entitled to the arrears salary as claimed. Arrears salary as found due, comma, the salary of the petitioner shall be released within a outer limit of 3 months thereafter. Next paragraph. In the according to this, writ petition stands disposed of at the motion stage without issuance of notice on the respondents.
Supply item 58.
May it be the last.
Yes.
This is the matter regarding promotion under FCI. Now, the issue herein is, in every food storage depot, there are a class of employees who are known as handling laborers. Now, the promotion is from handling laborers to the upper cadre of Mondal. Now, what has happened in this case is, there are two separate sets of handling laborers. One who are originally posted in that.
Issue notice, whatever.
I am praying for a stay order because it's
No,
a
it says that
palpably
it is
illegal
subject to
order.
outcome of further orders of the
Yes,
court.
ma'am.
Because he has already been given a promotional.
But if your lordship will just, if your lordship will just peruse one document,
Yes.
that would indicate that this is a clear case where he could not have been promoted. Because
It's okay, once he has been done. He'll hear them and then.
if a prima facie case can be made out, probably the promotions can be also suspended or restrained.
Promotion is very difficult to.
I understand,
say.
but because the
Hardly-
notification, which,
Hardly many people get an opportunity of being promoted.
but then if it is a promotion to which he is not legitimately entitled
We
to,
make that observation. We'll
only
consider it
one
when
small
further,
form of
my lord.
satisfaction.
Just
Father,
one. Yes, yes.
I'm sorry.
Rama.
Yes, one.
Yes.
FCI will subscribe to my views that there is a notification which says that there are two different class of employees. One who are originally posted in the depot and the other who have been transferred from another depot. And that notification says there will be two different sets of seniority list maintained and promotions will be given separately. Now here I can demonstrate that the particular respondent, he came from a different depot and therefore his name should have been in the separate seniority list. What has happened here in his name has been brought in the regular regular seniority list, and thereby he has stolen a march above me and he has been promoted. Now the documents herein will indicate that the FCI is maintaining seniority list separately, and in fact for this promotion also, their promotions have been given separately for the two separate classes of employees as the original depot laborers and the ones who have come from the other side. It is a simple case wherein there has been some, I do not know, maybe some oversight or maybe some illegality somewhere, but these persons admittedly are from a different depot. If your lordship will just see page 30, his own joining, wherein he says that I have come from Tinsukia, page 30, just for a moment. And regarding the procedure I'm saying, I strongly believe my friend will not object to that because that is the process that they are following. Separate seniority list, separate promotion. Page 30, one of the respondents, he has come from Tinsukia. So if he is from Tinsukia, he could not have figured in the seniority list that is maintained for the original depot employees, more particularly those handling laborers. The process that I have stated just now, I don't think there will be objection coming from the other side. This is the process that they are following. But only one thing, if it can be kept for instructions, this particular document, 14/12/2016, if you also will come to page 30, the joining letter, the respondent indicates to the order of transfer, that is 14/12/2016. If that can be placed, things will be clear. If they have actually come from Tinsukia, they could not have figured in the seniority list that is maintained for the original laborers.
You shows that there are two seniority lists. Where is
Yes,
that?
lordship. Yes, lordship. First, lordship will see the seniority, the notification, page 32. Just one thing, page 32. From the power from where they are maintaining these two separate lists. Page 32 is a notification of 12/7/2016. If a lordship will directly come to page 33, Roman 7. May I read Roman 7? As per existing instruction, workers under departmental and DPS's direct payment system category under their transfer by FCI in the interest of administration are entitled to get weightage of seniority at the new place. It has been decided that till further order, seniority position of group of workers of the gang transferred from one depot to the other will not be disturbed and separate identity of such workers will be maintained in the incoming depot so that it does not jeopardize the promotional avenues of workers already working in such depot. And the proof of this separate list, lordship will see from page 40. If lordship will first come to page 40.
Yes, of labors under FSD Hojai, original,
Yes.
origin.
This is the original. So they are people who are originally in that. Now here lordship will see the name of Sibesh Shah and Mongol Pandit, 2 and 3. Seriality number 2 and 3. So this is where that discrepancy has crept in. They are figuring in this provisional list. Now we have made our appropriate complaints and all this. Now if a lordship will come to page 45. Page 45, lordship got that?
This was prepared on
1/3/2024. Yes. And we had filed our objections to that. That your lordship will find at page 66.
66.
Yes. And that is yet to be disposed of also. And in the meantime, they have given these promotions. Page 66 is the objection. I am the applicant number 2. And at paragraph 3, we have categorically raised this objection saying that Sibe Shah and Mangal Pandit came from Tinshukia on December 2016. And therefore, they could not have figured in the list of original workers. And that the FCI is maintaining separate list that your lordship will find at page 45.
Yes.
Page 45. Lordship can see the heading. Provisional seniority list of handling laborers under FSD Hojai, originally from Bongaigaon. Then another list at page 46, originally from Tongla. And similarly, lordship will also come to page 49. There's a big list of people coming from, originally from Dimapur, page 49. So say that.
Yes.
So they maintain, based on that particular notification, they maintain separate seniority list. And based on this seniority list, they give the promotions. And that will also will see the promotions from page 76. Page 76. First, I am placing the impugned promotional order. Page 76. The following handling laborers of FSD Hojai, originally from Hojai. So everywhere they keep this category, saying one is the original ones and the others are from another depot. Now, how I am agreed by this is that in the original promotion, there were 5 posts that were to be filled up. Now, if these 2 persons whose name have crept in here would not have come into the picture, then I would have been selected because I said at number 7. So this is how my locus comes in to challenge this. Now, if a lordship will come to page 78. From the separate list, they give separate promotions. That can be demonstrated from page 78. This is another promotional order of the same date of 1/5/2024. Page 78. The following handling labor of FSD Hojai, originally from Sinamara via Dimapur, is hereby promoted to the post of Mandal. And similarly, lordship will see at page 79, 80, 81. So there is 2 different sets of employees having 2 different sets of treatment been given, and promotions takes place in a different independent manner to the same cadre of Mandal. But now their name having figured here, they have been selected or promoted based on the basis that they were the original depot employees, and thereby depriving my chances of promotion, which was apparently there because there were 5 posts which were to be filled up. This is my case. And the list is still provisional. We had filed an objection to that. It was not given due regard, and they proceeded to give these promotions. And one document I have seen at page 30, his joining letter that indicates that he came from Tinshukia, one of those private respondents. This is the case. If that can be clarified, whether they are from Tinshukia or originally from Hojai, things can be sorted out. Because
Yes,
the process
Mr.
we cannot deny.
They have filed their representation very recently, that is on 18/5/2024, my lord. What I was proposing that let this representation be disposed of within 30 days from the today, my lord. And plus my learned friend has pointed out one circular. I will take your lordship just 2 lines, page 33 again.
Yes.
Yes, my lord. Down below 7, Roman 7. As per existing instructions, workers under departmental and DPS category on their transfer by FCI in the interest of administration, are entitled to get weightage of seniority at the new place, my lord. So this is clear, my lord. Now, my learned friend has not clarified whether belongs to handling labor or ancillary labor, or whether those two labor who were transferred, whether belongs to departmental or DPS category. There are 4 categories of labors in FCI, my lord. That is departmental, DPS, and handling labor and ancillary labor, my lord. So at this stage, no stay may be granted, but my humble submission is that
His
representation may be disposed of.
Paragraph 2 is he's a handling labor.
The seniority list at page 40 indicates I'm a handling labor.
I'm
And the
talking
separate
about
list that they have
those two labor who were transferred from the different.
handling labor, same category. Let's will come to page 40 for a moment.
No transfer, you see, there are 2 things. Number 1, page 40 you are trying to
Page
show.
40, yes, your lordship. The provisional seniority list. We belong to the same category. 2 and 3, Sibe Shah and Manjit, HL, and number 7, Ram Udar Yadav, handling
HL.
labor.
This is a handling labor.
Handling labor. The category is handling labor. And the other list also, the category is handling labor. There is no sub-classifications again being recognized by this authority.
Because Mr. Singh, you see, normal service parlance, when please tell us the normal service parlance, we forget about this FCI for the time being. We want to understand the service law. Under service parlance, service law jurisprudence, if there is a seniority list which is provisional and there is a time for giving objections, can somebody be given promotion by overlooking the objections? Or if even after promotion, if an objection is raised within the time prescribed for giving an objection, how do you deal with the issue? How does the department deal with the issue? If there's a provision, supposing I am the departmental head, I issue a provisional list on 31st, 31/5, and on 1st I give promotion to someone.
I guess I have got your lordship point. But that's what I was suggesting, that this representation may be disposed of a time frame, my lord. Maybe 30 days.
The seniority list has a provision for submission of objection that is there recorded in the bottom of that seniority list, page 42. Page 42, NB. It's very small word also. Alphabets. Provisional seniority list of handling laborers under this as on 1/3 is
Within
prepared
7 days.
Within 7 days. And my representation that I have given at page 66, I have the registered post details, was on 12/3 also.
It's a list published on 1/3.
1/3.
Give it on 12/3.
Well, but be that as it may, this has been received by them, and yet it has not met any sort of rejection or even acceptance, anything. Seven days from the receipt of this list. So it's not publication, but receipt of this list with valid justification. So
there has no date in this
provision was there.
representation. The representation has no date, Annexure 6.
It's okay, you know it,
but
your officers will know it. Your officers will know it, because it says that from the date of from the 7 days from the date of receipt of a list. Receipt, I don't know. I don't know whether you serve it to each and every employee. I don't know.
I think they display it in the notice board. I also not having the instructions as it is, but the fact remains it has been received by them. And at least one consideration on that aspect was warranted.
We post it after 2 weeks. In the meantime, you get an instructions as to the disposal, whether their representation is disposed of or not. If he is given on 12/3 by registered post, let us say by 20 your officers will receive it. 23, 4, 5, 6. We are 3 months down the line.
Lordship may also pass an order that if it is not disposed of, it may be disposed of.
And regarding lordship, their continuation, because
We prefer it for 2 weeks. We are issuing a notice on the prayer for intimidate to be considered on the next returnable date. If they don't dispose of your representation in that time, then we take up your prayer for intimidate.
yes, obliged, lordship. The promotion will be made subject to further orders of His Honorable Court. Obliged, lordship.
Mr. A. Sharma and counsel for the petitioner, as well as Mr. D.K. Singh, Leonard, counsel for the respondent numbers 2 to 7.
7.
CVC will be there.
2 to 7.
And SK Medhi, Leonard, CVC appearing for respondent number 1. Next para. In brief, the case of the petitioner is that he is handling labor was joint duty under FCI on 18/12/1995 with his first posting at Hojai Depot. It is projected that as per the guidelines issued on 12/7/2016, the FCI has adopted a policy of giving weightage of seniority to the handling labor, based on based on their original place of joining. Referring to the documents annexed to the writ petition, the learned counsel for the petitioner has demonstrated that there is a provisional seniority list of handling laborers under FSD Hojai, and similarly there are separate provisional seniority list for such handling laborers whose original place of posting were at Tongla TUNGLA,
Bongaigaon and Dimapur.
Bongaigaon, Dimapur,
Amongst other, I have just placed.
Amongst others. Full stop. Next, but the further case of the petitioner is that provisional seniority list was published on 1/3/2024. Wherein the names of respondent number 8 and 9, namely Shivji SHIBJEE Sa SH and Mangal Pandit MANGL PNDIT, who were originally
Tinsukia Depot.
who originally belonged to Tinsukia, FSD Tinsukia.
FSD Tinsukia.
But their names came to be included in the provisional seniority list of handling laborers
Origin.
under FSD Hojai as an original appointee of the said FSD, and their names appear at serial number 2 and 3 of the said provisional seniority list. The learned counsel for the petitioner has submitted that the names of these, the respondent numbers 8 and 9 are reflected in their respective provisional seniority list of FSD Tinsukia, comma. There is every likelihood that the promotion granted to the respondent number 8 and 9 would have been allowed in favor of the petitioner. Next part. The petitions for the project that as provided for in this provisional seniority list, comma, the petitioner has submitted a representation along with two others, which was made before the divisional manager, comma, FCI, divisional forest, divisional office Nagaon, which was posted, which was sent by registered post on 12/3/2023, 2024. However, without taking any decision on the said representation, comma, the competent authority by the impugned office order dated 1/5/2024, amongst others, granted promotion to the respondent numbers 8 and 9. Hence, this writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. The learned standing cost for the respondent numbers 2 to 7 has prayed for him is granted 2 weeks time to obtain instructions as to whether the representation submitted by the petitioner within bracket annexure 6 for the petition has been disposed of by the competent authority or not. First off. Next paragraph. Having regard to the nature of challenge made in the petition, comma, court is inclined to issue notice of motion returnable on, we granted 2 weeks time. Yes. Returnable on 21/6/2024. Notice of motion, including notice of the prayer for interim relief. Next, requisite extra copies of the petition be served on the learned CEC as well as the learned standing counsel for respondent numbers 2 to 7 within 2 days. Next paragraph, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 8 and 9 by registered post with AD. Next paragraph.
Can it be through respondent number 7 depot because the address were from Bihar?
That company. Working at Hojai.
Not working at Hojai.
But he's in your,
Yes, but
in your place also.
He has given address
but
of
the
Bihar.
address of Bihar was given by the client, so the local address, if they have no objection to that from by the manager depot
No,
through
but
respondent number 7.
the problem is that we don't want these managers and all to
Yes.
start the postman service. I
That
have
is
my own
true.
reservations.
That is true.
Can make dusty service through at Hojai. If
Yes,
they are
Okay.
working.
We'll do
together.
that, we'll do that.
Full stop. As the addresses of the respondent numbers 8 and 9 are of Bihar, comma, the petitioners shall also take steps for service of notice on the respondent numbers 8 and 9 by way of Dasti. By routing the process to the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph.
Dusty at Hojai
The-
address. was.
Has the-
Dusty at Hojai.
at the Hujai, at FSD Hujai.
FSD Hojai, yes.
The next para. The pendency of this petition shall not be a bar for the competent authority of the FCI to dispose of the representation of the petitioner within bracket annexure 6 within next returnable date. Full stop. Next para. The promotion made in respect of respondent numbers 8 and 9 to the post of
Mandal.
to the post of Mandal at FSD Hojai shall be subject to further orders that may be passed on the next returnable date. When prayer for interim relief will be considered. Next para list on 20.
Can it be on 24th? We
24.
also have, yes, ma'am.
Okay,
It is not
24,
issued.
6/2024. Oh, 24 is, we have a fixed matter.
On 28th, my lord. 20. Or 27th,
26th.
26, yes.
27th, man. Thursday. If it
27
is
is
not
hearing day.
inconvenient.
We want to keep few days. I have many matters
26.
which are required to be heard. So this
26,
Tuesdays and Thursdays I am reserving.
For admission, not sir. The admission, otherwise it will come in orders again.
No, it will come in admission only.
Yes. Obliged. Obliged, Your Lordship.
Upgraded item 51.
Yes.
As per the last order, I have sent him a notice, lordship. So last page is the postal tracking, lordship.
No, just a moment.
Lordship.
Because if we allow this, consequentially the election petition has to be dismissed
My lord,
for non-prosecution.
there is some technicalities will arise. We decide to go. The technicalities is that after deletion of section 108 in 1966, 109 was introduced. There is a
Yeah.
procedure for withdrawal.
Representation of people, sir.
There was a procedure. This is not, if it is not a case of withdrawal, now I'll take your lordship to section 98 together with 1999.
Exact. Just a moment.
My lord. Second,
Representation of the people, sir.
If my memory is correct, the 108 was in fact deleted in 1966. Then possibly 109 was brought in. There is a procedure for asking for leave to withdraw. A leave application.
No, this is not the.
It is dismiss.
No, no. What is happening here? He is exercising the right available under the Guwahati High Court rules to withdraw as a lawyer.
That he can be allowed. But so
Yes.
far the fate of the election petition is concerned, since the petitioner is not there today, fate of the election petitioner is concerned, I have little submissions to make.
Yes.
109 will not apply because he has not sought for leave. Now, therefore, we come back to section 98 and 99. The 98 starts with the phrase called at the end of the trial, as your lordship got it.
Yes.
So 98 and 99 will not come in. So therefore, by virtue of section 87 of the RP Act, Order 9, Rule 8 will come in of the CPC. Because today is the date fixed for. If Order 9, Rule 8 is concerned, then the question is section 35 of CPC will come in. Because section 99, there is a provision for cost. That will not come in. Then again, I have to revert back the last part of section 108, because the registry has to be directed to inform the election commission of it. That procedure we have to borrow.
Correct. Correct.
So we have to go, there is another option left here. Now, the fact remains is that after Mr. Mishra left and then we got Mr. Nath, it was argued, this election petition, he was the respondent number 7 in the EP number 1. So his right to file WS was closed on 24th of August in this. That is, after 1 week, he filed this election petition, in verbatim copied from the EP number 1. So there the question of limitation came in. But so far the cause of action part is concerned, it is in verbatim copied from that. So it will have its own fate as the other one made it in the Apex Code. With an extra 2 grounds, is that it is barred by limitation because your lordship has already.
You can always take up the plea of section 10 at even if the issue estoppel will come in. That's what you want to say.
In fact, because it is all the same allegations, but this is cause of action part. But the first issue was, another point I took up as a preliminary issue, is that barred by limitation. Because he said that in paragraph 37 of the election petition, that now I can file if I am protected by COVID order. That your lordship, it is not reported, I don't know why. In another election petition, which I happen to appear with your lordship, has in tradeware discussed what is judicial proceeding and what is this, and it will not apply. So it is barred by limitation also. And second point, extra point that I argued was that since it is in verbatim copied from EP number 1, EP number 1, all contesting candidates were respondents. Here, while copying, he forgot that he is copying the prayer as well, without making the contesting candidates a party. So section 82 read with section 86 goes. So even without cause of action, whether there is cause of action or not, in the first 2 itself it goes. Now, your lordship will be now, there are 2 options left open to your lordship. Either we can go for the Order 9 Rule 8 route, or we can go for this route as well. This is what I wanted to submit.
You see, the long and short of it is that It'll be basically your call now to either go for a what do you call the term we can use is the trial part, and then decide that those issues.
Those issues.
Correct. That is number one. And the legal aspect is that you see if the petitioner itself is not there to present.
But he is the
Then-
opposite party in my application,
No, that's okay.
my lord.
But then order 9 rule 8 is inadvertent. We can't say that we proceed with the trial in the absence of the plaintiff because somebody has to open the.
Somebody has to,
Open-
that's why I
open
was
the
thinking this
matter.
morning.
So therefore,
Order 9 rule 8 will
order
come.
9 rule 8 will come in.
Come.
And then you see the issue which you were raising, please come to this 98.
Very- RPA. My lord is.
98, huh?
Page number.
The RPA. No, not page, section 98.
Section 90. Section 98 possibly will not apply.
You see, there's a at the conclusion of trial.
Trial is not
Correct.
complete.
No, trial is not concluded, but what happens if there is no evidence at all?
My lord.
So if there is no evidence at all, that is also a conclusion of trial.
But somebody has to, at least he has to come, appear.
No, if it doesn't come, then also you see
Yes.
at the conclusion of trial. Please, now we'll just examine this with CPC.
Now, CPC can work on this. Yes, this is another aspect I never thought. Yes. It must.
No, we are open to debate. I don't know. This is only a thinking aloud process. I may be horribly wrong.
The conclusion, my lord, it will not, CPC will not apply. The trial here begins from the date of issuance of the notice by your lordship. In the meantime, I come with order 7.
Yes.
Now, then if your lordship is taking the route of 98, then your lordship has to go to the merits of the order 7. Otherwise, because it has started with the issuance of the notice in the election petition in the RP Act. So, to come to the conclusion of the trial, in the midst of the trial, I have come with the order 7. I'm just thinking it aloud, my lord.
Yes.
If I have come at the midst of the trial with an order 7, and your lordship is resorting to any of A, B, C, D, A, B, C, then your lordship has to go to the merits of the order 7 and come to a conclusion that it does not have any merits, hence the election petition is dismissed.
No, just in the same process, please come to order 9 rule 8.
Order 9 rule 8. my lord. I never came across this kind of problem in earlier occasions.
No, it's okay.
Order 9.
Rule 8.
Order 9 rule 8.
We omit this for the time being. We come to 9 first, then come to 8 again.
My lord. Order 9. Yes.
Order 9 rule 8 is procedure where defendant only appears.
Order 8 is where defendant only appears. I
Yes,
appear.
you are there.
I appear.
So now we omit reading 8 and come to 9.
Reading.
9 says decree against plaintiff by default bars fresh suit.
He cannot come with an election petition.
He can't come up with an election period. Now it says where a suit is wholly or partly dismissed under rule 8, the plaintiff should be precluded from bringing a fresh suit in respect of so and so. And if you satisfy the court that it was sufficient cause for non-appearance, then it should first call upon for hearing. The court shall make an order of setting aside dismissal upon the terms so and so. Therefore, the restoration is a
No, restoration will not come in that way. RP Act has given a 45 days limitation that possibly court cannot extend it now. So this order 9, rule 9,
no, it is
that right will
restoration.
remain, but it will be barred by limitation.
No, it will be restoration. It is not a filing. 45 days of filing. Restoration is not filing.
No, bars a fresh suit. He is filed.
So this can
What
be
is-
restored. Under order 9 rule 9, there can be restoration. You may agree by that part. restoration is permissible. So a suit dismissed for default under 8 can be restored under 9. So therefore, you may have a say that yes, if it is restored, then the domestic sword is still hanging.
It's still hanging.
When he comes, how he explains the
My lord, then
non-appearance.
better since I given the bullet points, because I will have to think in this line. All this, because on cause of action, on not on the allegations already made with extra this bullet point number 1 and 2, if the order 7 application is also disposed of, that no one appears for the opposite party election petitioner, this is the outcome. Then in that case, election petition is dismissed on merits. This is my submission, my lord.
So we first release Mr. Kapil from here.
My lord.
We first release Mr. Kapil from here.
My lord, whatever.
Heard Mr. DJ Kapil, Leonard, DJ Kapil, the applicant in IA 1168 of 2024. Next one. The applicant is the counsel for the election petitioner in the connected election petition 5 of 2021. Stop. Next paragraph. In this interlocutory application, it is projected that the applicant had served a notice dated 13/2/2024 to the election petitioner, who is arrayed as respondent number as opposite party number 1 in this interlocutory application, which was sent by registered post with AD, and they said notice was duly served on respondent on the opposite party number 1, and in support thereof, the applicant has produced a postal track report which is annexed to this application. Full stop. Next paragraph. When the matter came up before the court on 22/4/2024, this court had directed the applicant to serve a fresh notice on the opposite party number 1, indicating that the connected matters, including IA 3102 of 2022, and the hearing on preliminary objection as to maintainability of the election petition, are next fixed on 24/5/2024. Full stop. Full stop. Next paragraph. The applicant has produced a copy of this said letter together with the original postal receipt of dispatching the said notice dated 25/4/2024 to the opposite party number 1. And the applicant has also produced a copy of the postal track report indicating that the postal article was delivered to the opposite party number 1. Next paragraph. It may be stated that there's nothing on record to show that upon service of the said notice, the applicant has submitted any document or record to show his presence, show his appearance in connection with this case on the date fixed. As the applicant has withdrawn his, has given notice to the opposite part number 1 about withdrawal of his wakalatama. It is, it was incumbent on part of the opposite part number 1 to either engage a new set of counsel to represent him in the connected election petition or to submit a memo of his own appearance before the court if he wishes to appear in person to contest the matter. Next matter. Having found that the applicant has complied with the order of this court dated 22/4/2024 and issued a second notice to the opposite party number 1 of his intention to withdraw his wakalatama. This interlocutory application stands allowed, and the current set of counsel appearing for the election petitioner in the connected election petition, inclusive of the applicant, are permitted to withdraw the wakalatama, and they are discharged of their obligation to appear in the matter. Next, accordingly, this interlocutory application stands allowed. Next. Okay.
With your lordship's permission, may I put a request to the benches then? That it may also happen that someone might have filed a ukalatnama, his name is not there in the cause list. So if there is any ukalatnama in the case.
No, it would come in election petition. It will normally come. Check with you, Pari. Your file correction. Check with you. Your file document file correction. Kalatma.
So it may take a different turn later because if someone has appeared, is filing a ukalatnama, and
okay,
then
get it check up. Check with you. Ukalatnama file correction. We'll check it up.
Coming to the merits, my lord, I will not take much time, hardly 5 or 10 minutes, my lord. I submitted certain bullet points.
Yes.
Bullet point number 1, my lord. I will not take your lordship to the entire bullet point. It is on this point, my lord. The question was.
We already have 12 pages of your notes.
My lord.
Your submissions have been encapsulated in 12 pages of notes.
My lord. That whole submission has.
No, but please refresh the memory.
Just
memory is something which is
lord,
failing.
I'll summarize again, my lord, that bullet point also. It stands like this.
Just a moment. Let me repeat so that.
My lord.
I'll detain it.
My lord.
Now, about the your first submissions were on the
preliminary point of limitation
of the Sumoto Supreme Court decision.
Yes, and the issue was whether it is barred by limitation.
Yes, you projected that it was the proceeding before the stamped report is not a judicial proceeding.
After that argument, my lord, your lordship has already passed an order. It's not reported yet. That in case of RP Act, because Section 116A appeal to Supreme Court, this is condonable and a judicial proceeding. Section 81, act of presenting before a stamp reporter is not a judicial proceedings. That judgment possibly was not there, just come later if I can find it. That in the other, there are 5 election petitions.
Yes. So,
here, my lord, what happened? Only
so that is one part.
My lord.
And you are referring to this section 81, you are saying whether the delay is condonable or not. So you are now saying that this will be covered, that issue.
Because the same point came up before that ESLA case to Nijamuddin.
Last document file is 7/6/2022.
Then it's
So that system,
But it is better to at least,
no, it's okay. You are absolutely right. Yes, this is, I remember this.
this is your lordship, but I think,
I don't know whether it is right or wrong.
no, that is right.
Okay.
That is right. In fact, Kerala High Court, if I have the copy, although is not referring to Guwahati High Court, taking up the same logic.
Is it?
My bad.
Okay.
Now I am told, because it is not giving any credit to my High Court, that is the order that was referred to.
Okay.
Kerala High Court, but Apex Court it has not gone to.
So your second leg of argument is based on bullet point number 2.
Bullet point number 2, my lord.
The orders which can be passed in an election petition.
Bullet point number 2, yes.
You're referring to section 98.
Yes. My lord, what has happened?
You are referring to prayer number A and B. And you are trying to show that one part of the prayer, A, relates to section 98, read with section 100.
100 and 98A. Under 98, there are 3 types of orders, your lord. Dismiss. B is, your lordship will kindly see 98.
98, yes.
First is dismissal of the election petition. Second is declaring the election void. Third is declaring the election void and declaring him or any other candidate to be elected.
So that you're saying that is hit by non-joint or necessary parties. That is
because section 82 provides.
Okay, I remember it.
Yes, section 82, your lordship will kindly see who are the parties. And 82 violation attracts section 86. So that is gone.
Yes, okay. And second part is the prayer B.
B.
You're saying it is relatable to 98B.
98B, because what
you are reading this with section 101.
101, he's 101 because he is mentioning, copying it from the EP
It's
number
okay.
1.
It's okay.
In the EP number 1, this problem was not there. All the contesting candidates were there.
So your substance factor argument is that the consequences of section 88 leads to the dismissal of the election petitioner for non-compliance of section 81 and 82.
My lord.
Correct?
My lord. 82. 81 is 45 days. Section 81 provides for limitation.
But your argument to be recorded is 81 and 82. So it should be 82 only.
82.
Not 81.
No. 82, your lordship will kindly. 82 refers to what should be the parties. Then 86 says, if these parties who are required to be made parties are not made, then section 86, it says it will be dismissed at the threshold. And that threshold order will be deemed to be an order passed under 98.
98.
My lord. And the third point.
Then you came to bullet point number 3, that there are no grounds referable to section 100 and 101.
That point is also now settled, that only one judgment was there of the Apex Court, now the second judgment.
Second one has come.
The court would be.
The non-reference to material facts.
Yes, my lord.
That's
Because that material facts or cause of action is there or not, why I am not taking your lordship's valuable time, because it is in verbatim copied from the EP number 1 out of the frustration that his right to file WS was closed on 24th of August. Then he said that I have a right to file election petition now, and I am protected by COVID. That is the point.
Then you come to this. You are not there, Mr. Barua argued, regarding the cause of action.
That is, my lord, that cause of whether allegations make out a cause of action.
There are 4 allegations.
Yes. And all the same allegations of my lord.
And then again, reference to the provisions of 81.
On grounds.
Then reference was made to section 99.
My lord.
Which is incumbent that the petitioner must prove that there was any corrupt practice.
But now those things will not come in because first is the cause of action. Then the proving part comes.
So then the second, 3 and 4 will not be required now.
Not be required.
1 and 2 is the
Sufficient to
sufficient.
Because your lordship will see there are empty number of judgments when under order 14, most probably rule 2 or 2, Rule 2.
14.2, Rule 2.
Rule 2. It says, if the judgments are there, I have already annexed that normally question of limitation is a mixed question of fact and law and fact. So it should be always deferred till the main trial. But the apex court has clarified that if the factual part is admitted, only what remains is to be only the legal part, then it has to be framed as a preliminary issue. Now here paragraph 37, he himself has said it is barred by limitation otherwise, but I am protected. That part is the legal issue. Because he is not saying that I am here or I am there. He says otherwise it is barred. But I am in paragraph 37, I am protected by that. That is a question of law to be decided. Your Lordship, in fact, in the other that I have forgotten that Nizamuddin judgment, this point already your Lordship has touched. That factual part is gone. Your Lordship in the last part of that Nizamuddin judgment has also referred to all the Supreme Court judgment. Last part, if my recollection is correct. Why?
Yes, Nusli Nevidi.
Yes, Nusli Wadia and all.
This issue, we are on the administrative side also taking it up.
My lord.
That the last part of the observation here.
My lord.
We are taking up in the administrative side and rectifying it.
Because your Lordship
it cannot be endless.
Your Lordship is clear. What is exactly, so apex court has said, it must be, it is condonable by a court or a tribunal, provided it is condonable in a judicial proceedings. And it is condonable, outer limit of which is condonable in the statute.
No, what I'm trying to express is that this on the administrative side is, we are also saying that the defects, even if it is there, should be brought to the court.
In that case, so section says that it is not the, your Lordship has commented somewhere, it is not the job of a administrative side to say what is condonable and not condonable. Your Lordship has used a little.
So we are taking it up. But the difficulty is that we are so overworked that we don't have time for this administrative works and application of mind, because it needs a total recast. We have to draft a new rule and then present
And
it.
Guwahati High Court rules also has to be most probably looked into.
No,
The
that is
election
what we are
rules.
trying to touch.
My lord.
That chapter 10.
Yeah, chapter 10.
The chapter 10, we are.
It has to be recasted.
We have to recast it.
Recast it.
Due to paucity of time, hardly we get any time.
But I remember in 98, 99, around that time, when Mr. Honorable Chief Justice Mongia was there, first the committee was formed, then it is brought to the Honorable Judge, that whole draft. In fact, I was fortunate enough to.
No, usually what happens is that by the time we delegate to someone else and explain what we want, that is the time required for us to, we can completely draft by that time. Because election laws is not very easy for others to understand unless I explain it to them.
Yes.
Because we also took so much of time from you to know the niceties of the
decades for me, my lord. It took me decades to understand this.
So I have these things and to explain it further needs more orientation.
I understand. I can well appreciate it. Otherwise, it may get more complicated later on. Further complication will arise.
We engaged even the draftsman from the Legislative Assembly for some exercise. There's a communication gap. The legal framework we are doing, we're trying to express, and the legislative form of drafting is quite
But
different.
in 98, who later on he was elevated, Honorable Justice D.P. Kotoki, when he was on this side. Then Honorable Justice Mrs. A. Hazarika, myself, and yes, a committee was formed. Then report was submitted. Then it went to the full court. That was the procedure. Now your Lordship is rightly saying it will take the whole complicated further.
No, those were different days. You see, we'll tell you why. If you can share it. So maybe perhaps after so many years you are now disclosing, but at that point of time when those burden was given, people used to keep it secretive.
Yes, yes, yes. Yes, that time we used to meet somewhere, not in the High Court.
No.
The provisions were made by the High Court, all administrative backup for us to meet.
So, times have changed.
98, of course, it is 30 years back almost. How bless your lordship.
I would say that this is this is 3102. But Mr. K. V. Patel, and Senior Counsel, assisted by Mr. I. Kalita, Counsel for the applicant. Next, now if on call for the opposite party number 1. Next, it may be mentioned that the learned counsel for the opposite party number 1 had filed IA Civil 1168 of 2024 to be recused from appearing for the opposite party number 1, who is the election petitioner in the connected election petition 5 of 2021. As a notice of withdrawal of Wakalatam was duly sent to stop by a separate order passed today in the said IA Civil 1168 of 2022. The said application has been allowed. Next, none appears on call for the opposite party number 1. Next, the learned senior counsel for the applicant has advanced his submissions on the in this interlocutory application, and has also filed a note of submissions, which is made a part of record. Note of submissions, and he relies on the note of submissions submitted on 20/12/2022. They said that the same is made a part of record. This argument is concluded, has been reserved.
My lord, may I
Now,
have
there's another one, there's another IA. What is 241?
My lord.
241.
241 is an application under Order 7, Rule 11 CPC. This is the Order 7 application.
No, that was 3102. Now this is what we're doing.
3102 is an application under
For preliminary point on limitation.
My lord, this is a point of limitation. And the other Order 7, Rule 11 is 241.
Okay, same order here. 241 is an application in the Order 711 CPC.
Right.
Same order. Here you have filed your written submissions.
My lord, for the preliminary.
Ah.
That bullet point number 1. Bullet point number 1 is the
Just shows how is it?
issue of limitation. Bullet point number 1.
Ah.
No, it should not be so bulky. It's a small note I prepared out of. Bullet point number 1, because
No, we have this one. Yeah, bullet point number 1 is this one.
No, while I was arguing, my lord, I have made it more concise, if your lordship so permits,
Please pass it on.
because bullet point number 2 today.
And what is this bullet point number 2, 3, sorry, 2, 3?
2 is non-joinder of parties. Bullet point number 2. Can I give I have made only 2-page note so that bullet point number 3 today. Bullet point number 3 is that it is barred by law.
Yes, Muni Raju.
Yes, Muni Raju. Bullet point number 4 today.
And FA Sapa.
Yes, yes. And issue number 4 is whether issue of cause of action. That is that because cause of action comes from the material facts and all. These are the 4 bullets. Because I didn't want to burden your lordship with all the written note, only bullet points.
And what is this comparison on the preliminary objection? Samant Balakrishna, George Fernandez.
My lord.
Why was this given?
Well, these are on Mary George Fernandez, my lord, regarding preliminary
Just say this.
Nulsi Wadia was for that, my lord. Bullet point number 1.
Nulsi Wadia is the number 1. Limitation.
My lord.
This is the one you gave us.
My lord, this is regarding, I addressed your lordship on the point whether now they can retract from the prayer made. Because section in the prayer, they have resorted to 101 without making all of them party. Because normally the question sometimes arose whether court on its own can resort to order 23 by deleting that portion. And although they are not parties, but in RP Act, that once the parties are not there, or then in that case, they cannot make an amendment or make.
This is a point you raised in earlier petition.
Earlier.
Okay.
Those cases, my lord, your lordship has already discussed in the other judgment. In so far my recollection that Nizamuddin. Nizamuddin. Sometimes names I forget. But I fail to understand. These are the issues of law which your lordship have decided. If the registry can at least inform the publishers, it will be helpful for the bar.
No, there's a reason for it. At times we forget to endorse in the order, there is to be reported.
Oh, I said that procedure I don't.
Because I have a feeling, which is a feeling personal to me, where where I think that if there is anything, any law which is not yet reported or requires to be reported, then we endorse it. But all my orders are not reported, that's why.
If it is reported, our High Court can take the credit that it was reported in this law point. Our High Court was the first to report. I am thinking in that line.
Okay, I will check up.
Obliged to much.
In the election petition, you write, non-efficient call for the election petitioner, Mr. K. Patak, and Senior Counsel, Assistant Mr. Ike, Karita Counsel for the respondent is present. In view of submissions made in IA civil so and so, the proceedings of this election petition stands deferred till the disposal of the threat to IAs. So the listing of the matter would be notified letter.
Obliged.
Item 20.
Yes, who is for the government? You are required to produce the DPC minutes.
Additional system, yes.
Minors too. Copy provide me. Lordship, I have the minors of selection committee of 8/10/2020, Lordship.
2022, I think.
No, it's 2020 only, Lordship, that has been communicated to us.
I don't know, because in the order sheet of 30/4/2024, the court has recorded DPC minutes of 8/10/2022. It should be
20, not 22.
20 is
20.
Lordship,
Okay,
8/10/20.
I don't know.
It is the subsequent
Does-
DPC mail.
Lordship, I have only one copy. I have not xeroxed it, Lordship. Oh, no. No, this is wrong. This is wrong.
This is 19.
This is Lordship.
No.
I have mistaken.
DP is still pending.
No, my DPC, my lord, what happened in this case, my case was not considered by DPC on its meeting held on.
No, I'm asking you a different question. My question is that whether your departmental proceeding is
No,
pending.
no, my lord, it is,
It
I am
terminated when?
completely exonerated and my,
It was terminated when? When did it terminate?
my lord, just a minute.
Lordship, may kindly have a look in our affidavit filed by respondent number 1 and 2.
Can you just tell me the date?
Yes, Lordship.
What is the date when the DP was terminated?
DP was terminated, letter on my.
Suspension period of the petitioner was regularized by the order number so and
No,
so
no, The
dated.
date of termination of DP, that is the only question I'm asking for the time being.
Okay, Lordship.
No, not the regularization. The DP terminated when?
The petition was not finalized.
Date has not been
Yes,
given, my
the
lord.
DP drawn against the petitioner was not finalized till the date of holding the meeting of the Departmental Selection Committee, Lordship.
It was not
This
finalized.
is
That
the-
means still this
You have to understand for a letter from what to the.
DP has been finalized, my lord.
8/10/22, it was not finalized.
But DP has been finalized, my lord.
Tell me the date. This is the only question I'm asking.
Lordship, may kindly see this letter. This is the letter, this is the communication, this is
Just
not
tell
a.
me, just tell me the date.
But there is no date, my as far conclusion of the said departmental proceeding. The departmental selection committee in its meeting 8/10/2020 recommended Sri Robindra Deka inspector to the post of superintendent, but keep the recommendation in a seal cover due to pending departmental proceeding.
So it is
against it.
pending till that date.
Not my lord. After
Because-
conclusion of the said departmental proceeding, drawn up, there is no date, my lord. And then the inspector and his complete exoneration of the level charge against him, he was promoted the post of superintendent with respect to 7/11/20.
8/10/20, there was DP continuing, Lordship. That's why it was kept under seal cover, Lordship. But the exact termination date, Lordship was giving, but.
It is
You
before
see,
the promotion, I think.
That's a requirement, I think.
Yes,
so,
Lordship.
Because if on that date is terminated,
Yes, Lordship.
then his DP will take effect from the date when his promotion is otherwise due.
Yes, Lordship. His promotion has been given a retrospective effect, Lordship.
Has been given.
Yes, Lordship. This is in our affidavit, page 34.
Page 30.
That means it started from page 33, Lordship, paragraph 9, Lordship. In paragraph 9, second paragraph, we have stated these things, Lordship. May I read, Lordship?
Yes.
Yes, Lordship. Paragraph 9, first portion, half, I'm not reading, Lordship. From the second paragraph, it is it is further informed that the petitioner was recommended for selection for promotion to the post of superintendent in the year 2020 by Departmental
You are
Selection
reading which
Committee
page?
in its meeting held on
You are reading which page?
page 33, Lordship.
Yes, paragraph.
Paragraph 9, Lordship.
No, para 9 is in 34.
Oh,
Yes, please continue. Please read.
in this country, it is further informed that the petitioner was recommended for selection for promotion to the post of superintendent in the year 2020 by Departmental Selection Committee in its meeting held on 8/10/2020, which was kept under seal cover due to pending departmental proceeding, and was later promoted to superintendent by number so-and-so dated 19/8/2021 with retrospective effect from 7/11/2020. He was further promoted to the post of assistant director by number so-and-so dated 27/12/2023, Lordship. And paragraph 11, we have stated that the suspension period of the petitioner was regularized by order number so-and-so dated 16/10/2020, Lordship.
Nothing remains in the writ petition.
My lord, my case is, this is a subsequent event. Whatever submission is made by learned file is subsequent event, my lord. Lordship may kindly see affidavit in opposition.
I'm reading from the
Para
affidavit.
9, my page 33, with regard to the statement, due to the inadequate ACR in respect of the petitioner. At the time of meeting of the Departmental Promotion Committee 26/2/2019, this is under challenge, my lord. However, the DP drawn against the petitioner was not finalized till the date of holding the meeting of the Departmental Selection Committee. What happened, my lord? My case was not considered by the Departmental Promotion Committee meeting in its meeting held on 26/2/2019, my lord. That is under challenge, my lord. My junior was promoted in spite of there being nothing against me. And why the departmental committee has not been recorded its reasons to be recorded, my lord. Lordship may kindly see my departmental selection committee decide not to recommend the remaining officers in the rank of inspector under the zone of consideration promotion to the post of superintendent due to unavailability of required ACS and APS. This could not be a ground, my lord. They are on the subsequent event, my lord. Lease has to be decided on the date on the lease occurs. Lordship may kindly see my affidavit in reply, my lord. Paragraph 9, the reply to the paragraph 9, my lord. Petitioner begs to state
Yeah,
that,
just now.
my lord.
Affidavit requirement of 9 different.
Lordship may kindly see the writ petition also, madam. That is the prayer in the writ petition.
Where is the relevant entry on your ACR?
My lord,
Where is the relevant entry in your ACR?
the ACR was not submitted before the DPC, my lord.
It can't happen. A DPC cannot sit without your ACR.
My lord, that is the happening, my lord. Lordship may kindly see their affidavit, my lord. Lordship may kindly see the affidavit in reply. I have annexed the Departmental Promotion Committee minutes on 26 to 2019, my lord. That is dear, my lord.
Page.
Page 57, 58, 59. Lordship may kindly see the last thing, page 59, my lord. Departmental Promotion Committee decided not to recommend the remaining officers in the rank of inspector under the zone of consideration for promotion to the post of superintendent due to unavailability of required ACRs and APRs. What is the rule says, my lord? There is nothing, my lord. No reasons has been recorded.
You are reading where?
I am page 59 of the minutes of the meeting, annexed with the
No, where you are reading? In page 59, which place you are reading?
last paragraph, my lord.
Last paragraph is serial number D, selection against
No,
17
my lord,
vacancies.
it is page 59. Affidavit in opposition.
59,
Affidavit
that's
in
what I'm
reply, my
reading.
lord.
I'm reading 59.
Affidavit in reply, my lord.
I'm reading 59. 59 is serial number, page number 2, internal page number 2.
From 57 onwards, the minutes of the meeting, my lord.
No, it is page 58 here.
Okay, something wrong.
So it will be 60. Okay.
Okay, my lord, last paragraph, kindly.
Due to non-availability of the required ACR and APR.
My case is not considered. That is not a ground for no consideration.
Yes, he is right. Mr. Chaudhary, Mr. Chaudhary is right.
My juniors are promoted, my lord.
Yes, Mr. Bhattacharya.
Yes, lordship.
Your counterpart, Mr.
I
Bhattacharya, is
don't
right.
have this document with me, lordship.
But it is their document, my lord. I just
No.
annexed.
It is there that I am not countering. I'm saying the affidavit in reply that has been filed by them, lordship.
Yes, we did it, so. Thank you, lord. Okay, thank you. Last quarter, that's also.
Please give her a copy.
Lordship, I have, lordship, then kindly allow me 2 days time, lordship. I also have to go through this and also required to take on instruction, lordship. Why
No,
exactly?
Usually this,
Even if you-
Yes, lordship. This
Even if-
APR and ACRs,
No,
yes.
even if you
Yes,
take instructions,
yes.
it doesn't help you because of the fact that
That I know, lordship. What rule says, lordship, I need to go through this only, lord.
because if you see at that point of time when page
60.
This minutes was prepared
Yes, lord.
on 26/2/2019.
Yes, lordship.
After that, the second DPC is
Yes.
the document you are now produced. Correct.
Lordship.
This is the 20.
20.
So here also they don't say. Well, okay, in 19 it was not there. In 20 they would have said that on 20 we consider it and then recommend his promotion from the from 2019. 1 year you can't
Lordship.
just naturally from his career.
Lordship.
When the rule says, my lord, can I have a look at the rule, my lord?
It's not required. Not required. In a DPC, if you conduct a DPC without giving them
Yes,
the
Lordship.
ACR, it itself is illegal. In fact, the entire what you call this the petition would be
Yes,
entitled
Lordship.
consideration.
Lordship, kindly take it up on next Tuesday, Lordship. In the meantime, I shall prepare and appraise your Lordship on this.
Because it can't be rectified. No,
And
no,
that I know, Lordship.
no amount of
Yes,
supplementary
Lordship.
materials.
Yes,
Change the
Lordship.
view of the court.
Each time they are coming with a new advocate and taking time, my lord.
New
But-
advocate,
okay.
Lordship, this is,
So
we are
we
bound
can't help
to, Lordship.
My lordship,
Mr.
kindly see
Bhattacharya.
the note sheets, my lord. The
Mr.
order
Bhattacharya,
sheets, my lord.
No, no,
Umpteen number of dates have been taken, my lord.
understand, but it can't be helped.
In that case, lordship make the case pardoned and.
No, no,
Whatever, I am praying for a short time only, short accommodation.
The matter may be kept as pardoned.
no partner business.
My lord, it is traveling from judge to judge.
I understand.
Ultimately, everywhere they are paying for time.
Partner, Mr. Bhattacharya,
My lord.
such a small brain.
Nah, we are here to assist
you-
your lordship.
You have seen the last. No. When it is partnered, then only I can help myself. You
I
can't help
am
me.
here to assist myself.
No.
He is there to assist you, your
No,
lordship.
not as partnered. You assist us on the.
It will be listed in
Tuesday.
another court there.
we don't know.
There will be another
We
view.
don't know. There is no guarantee that today when I leave the court, I will reach home. There is no guarantee.
Everything is guaranteed. I may be stuck here by a trap, my lord.
That's why no guarantee. No partnered business.
Nothing is guaranteed in this world.
You've seen the last volume, in which I have made partnered. I have to deliver judgment now.
Anyway, let it be on Friday, my lord.
Friday should not get. Today they are celebrating.
No, Friday there is no celebration.
Today there is a unique celebration.
My lord.
People who have lost is also celebrating. People who have
Lost
won is
is
also
also
celebrating. There's no untoward incident. Public is also celebrating.
This democracy is going on fine, my lord.
Okay, Tuesday, but we'll not adjourn on Tuesday.
Yes, Lordship.
Mr. D.N. Bhattacharya, learned counsel for the petitioner, has been able to demonstrate that when the earlier DPC meeting was held on 26/2/2019, the ACRs and APRs of the petitioner was not placed before the DPC. And therefore, the DPC had decided not to recommend the remaining officers in the rank of inspector under the zone of consideration for promotion to the post of superintendent due to unavailability of required ACRs and APRs. Next para. This court by order dated 30/4/2024 I directed the government advocate to produce a copy of DPC minutes dated 8/10/2020. First off, the Mrs. M. Bhattacharya, learned additional senior government advocate, has produced a copy of a photocopy of the minutes of DPC held on 8/10/2020. First off. On a Rabindra Deka. First of the first of as to the said minutes, as against the entry of the petitioner, it is mentioned that departmental proceeding against the petitioner is pending. Full stop. Therefore, the DPC had decided to keep the recommendation in respect of the petitioner in seal cover. Full stop. Next, the learned additional senior government advocate has referred to the affidavit in opposition filed by the respondent numbers 1 and 2. And it is submitted that where is the date, Mrs. Bhattacharjee?
Lordship, in paragraph 9 of the affidavit filed by on behalf of respondent number 1 and 2, Lordship. In paragraph 9, this is on page
Oh, in
35,
paragraph one.
Lordship.
Okay. So first off, then in paragraph 9 thereof, it has been stated that the petitioner was thereafter promoted to the post of superintendent, FCS and CA. FCS and CA. By order dated 19/8/2021 with retrospective effect from 7/11/2020. Full stop. There's next paragraph. Therefore, there is no explanation as to why the case of the petitioner for promotion was not considered from the effective date in respect of which the DPC meeting was held on 26/2/2019, and why the petitioner was not granted benefit of promotion on and from 7/3/2019, the date on which the respondent numbers 5, 6, and 7 who were junior to the petitioner were given promotion. Next paragraph. The learned additional senior government advocate praised for and is granted time till
11th, Lordship.
11/9/2024 to address the court on the said aspect. Next paragraph. List on 11/6/2020.
Yes, Lordship.
4.
Deeply obliged.
Item 22.
Yes.
My lord, this is an application under section 11 for appointment of arbitrator. And there is no dispute about the existence of arbitration agreement. And there is also no dispute that I have invoked the arbitration clause, but they failed to appoint the arbitrator. So now, as per section 11(6)(a), your lordship may appoint the arbitrator.
Okay, what is your stand, Mr. Mehdi?
We will see paragraph 15, my lord. Section 12, subsection 5, my lord, for waiving, my lord, this we wrote letter to appoint, my lord.
I do not get it. Please repeat again.
The department wrote letter, my lord, to appoint the arbitrator from our panel, my lord. And waiving
That
this.
is now not
Yes, yes,
permissible.
my lord, that is
Under the
I understand.
amended act.
Yes, my lord.
We appoint an arbitrator.
Yes,
right?
yes, yes.
Heard Mr. R. Hussain, learned counsel for the petitioner, as well as Mr. S.K. Mehdi, learned CGC, appearing for the respondents. Next, Para. By filing this application under section 11 of the Arbitration and Conciliation Act, 1996, the petitioner company has paid for referring all the disputes and all the disputes to be referred to the sole arbitrator. Bereft of details, it would suffice to mention for the purpose of this order that that pursuant to an tender issued for a certain work, the bid submitted by the petitioner was accepted by the acceptance letter dated 11/1/2018. And the tendered work was required to be completed in 18 months' time. Full stop. In course of the in course of the work, in course of the implementation of the contract work, contract agreement dated 27/2018. It is projected that the respondent authorities had issued a termination notice dated 4/12/2020. And the contract was terminated on or about 7/12/2020. Full stop. The petitioner had made mandatory claim against the respondents by a letter dated 4/1/2021. In response to which the respondent authorities by a letter dated 25/2/2021 requested the petitioner to submit their consent for waiver of section 12 within bracket 5 of the Arbitration and Conciliation Act, so as to enable the respondent authorities to appoint arbitrator from their own panel. It's wrong. It appears that the you did not say no.
No, yes, we did not waive the our right.
So the
But no response was there, man.
the petitioner
No
did not respond to the said request. And therefore, it is projected that the petitioner had not waived the requirement of section 12 within bracket 5 of the Arbitration and Conciliation Act, 1996. And thereafter, this application has been filed. Next paragraph.
Rather, we declined, my lord, at page 153 and except 22.
No, in your petition, you don't say anything.
Yes, petition.
In your petition, I don't find it.
No,
Petition made.
Is there any statement in any of the paragraphs saying that?
no, man.
Because if I start reading page 153 at home,
Petition is
particularly, I don't think you're expecting that I would read the page 153. Next paragraph. The Lorette CEC, by referring to the stand taken in the affidavit in opposition, has submitted that the petitioner had defaulted in showing the requisite progress, and therefore, after service of 48 hours notice, the work was terminated by issuing termination notice dated 8/12/2020.
Sufficient time was given. Sufficient.
Yes, yes. Accordingly submitted that for reasons assigned, the stand of the respondents is that certain part of the claim of the petitioner relating to refund of security deposit, etc., are liable to be forfeited. And it is also projected that that in the meanwhile, the final PVC bill has been paid to the petitioner, notwithstanding that certain supplies are still pending. You said security deposit, you also say earnest money and security deposit. Next, but it is also stated that as per the railway general causes of contract, comma, it is provided that the railways would have a panel of arbitrator, and therefore a letter dated 25/2/2021 was issued to the petitioner for submission of their consent for waiver under section 12 within bracket 5 of the Arbitration and Conciliation Act. Arbitration and Conciliation Act 1996, which was not responded to. Most of the CGC has submitted that in view of the conditions contained in the GCC, this is also covered by the relevant clauses in the contract agreement. The appointment of arbitrator should be left to the discretion of the NF railway authorities. Next paragraph. There is a judgment of Supreme Court on that 12(5) waiver.
Waiver. That judgment.
It says that you have a right of not doing that.
Yes. 12(5) under section 12(5) it is there. In writing, the waiver must be in writing.
Asking that. No, not that. There is a judgment to support 12(5).
Judgment I have not brought to the.
Okay. Next paragraph. Consider the submissions made by the run counsel for both sides. First off, in view of the prescription made in subsection 5 of section 12 of the Arbitration and Conciliation Act, 1996, which provides that notwithstanding any any prior agreement to the contrary, any person whose relationship, with the parties or counsel for the subject matter in dispute, falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. Full stop. Therefore, notwithstanding that the parties have agreed to a manner in which arbitration shall be proceeded with, but if there is an empaneled arbitrator by the NF Railway, they would have certain amount of relationship with the respondents, and therefore they would be covered by the 7th schedule, the Arbitration and Conciliation Act, 1996. More so if the proposed arbitrators were ex-employees of the NF Railway, of any of the railway any railways in the country. Full stop. Next para. As the petitioner is not waived its right for appointment of departmental arbitrator under section 12 within bracket 5 of the Arbitration and Conciliation Act, 1996. The court is inclined to appoint Mr. A.M. Honorable Mr. Justice Ajintamala Bhujar, former judge of this court, as the sole arbitrator to arbitrate all the disputes between the parties arising out of or in connection with the contract agreement dated. What is the date?
Date, my lord, 27/2018.
207/2018. You see, it proposes the name of the court proposes the name of counsel. Next paragraph. Accordingly, the petitioner shall take steps as per the requirement of section 11 within bracket 8 of the Arbitration and Conciliation Act, 1996. So as to enable the proposed arbitrator to give a disclosure in writing as per the requirement of subsection 8 of section 11 of the Arbitration and Conciliation Act. Full stop. Next paragraph. Requisite steps will be taken in 2 days by for service of notice along with the certified copy of this order. Stop. On receipt of the notice, the learned proposed arbitrator is requested to do the needful within, preferably within a period of 2 weeks thereafter. Next paragraph. Based on 28/6/2024.
28 year court arbitrary. Date may be after 28, 28.
He will not be there because then we'll be having vacations. Then we'll have to prepone it. We make it 26th then.
26th June.
26/6/2024. You have to take steps as regard you. This disclosure is required to be made mandatory.
Certified for.
Item 23.
Yeah, please, your lordship. Kindly see order dated 10/5/2024. The PNRD was supposed to get instructions.
Yes.
But I have some instructions. Government has sanctioned the parties.
Are you getting provisional, what do you call it?
Oh my God.
Family pension? No.
Petitioner has not received any relief till now.
You see, this doesn't take us anywhere. This set of instructions you already produced earlier.
Well, this is pertaining to the arrear salary that was the retire benefits. It was arrear salary was due payable to the petitioner. So as far as the arrear salary is concerned, that has been sanctioned, my lord, and it's awaiting.
No, it's not sanctioned. You are requesting the government for sanction.
Approval, my lord. That approval is being
No,
sought.
no, that instructions we already have here. This is a duplicacy of what we are now giving. This we have here.
And my lord, as far as the family pension part is concerned, at page 43, my lord, and 42 of this writ petition, the concerned BDO had provided the commissioner with his service book, my lord, and has informed the commissioner that family pension is due payable to the petitioner. That was sent way back in 22. However, my lord, no effective action has been taken till date on the commissioner's part. All his service particulars have been handed over, my lord.
Where is your application for family pension? Where is that application? Your application is not there. It's only the letter of Gaon Panchayat. Sorry, the BDO.
So petitioner has not filed any representation till date. It's not there in the report. This is internal correspondence.
No, because for this page 43 shows that the authorities are writing that on 22/12 the husband of the petitioner had died. Somebody must have informed them, but their starting correspondence in 2022. And now we are in 2024. Yes. Mr. Babu, please give us some solution. Because now they are, you see, now the departmental commissioner is writing to the secretary, principal secretary for sanction. Then he will write to finance.
No, sanction, my lord, here it is, he was already in a cadre post, regular post, regular, so therefore, no, my lord, but I am.
It may take.
No, process will not go to the finance department.
Not go.
It will not go, because that is already delegated, that power is already delegated. Because entitlement to pension as such is not under dispute here. What it is gathered from the materials. Entitlement to pension at the first stage.
It doesn't go to you. So there's no time
Yes,
lag. Only the authorities will have to sanction it, it goes.
Yes, and
Okay.
sanctioning only if, my lord, there is a, my lord, requirement of any supplementary budget. If there is any dearth of funds, then of course, my lord, we will step in. But here is a case, my lord, where the power is absolutely delegated to the administrative department concerned.
So, Mr. Hazarika, we are returning you this document. We provide you 2 weeks time to inform us as to whether the commissioner has, principal secretary has taken any decision.
Yes, ma'am. Because he was already getting a regular scale of pay. He's a government servant within the 1969 pension rules. So Rule 31, all 3 conditions are fulfilled. So therefore, there is no bar in, my lord,
No,
denying
that is
him
why I
the
wanted to
pension.
understand. Otherwise,
Yes.
people will hang for years together.
Yes, ma'am.
Okay.
It is only, my lord, that it is revolving within the department itself.
It's okay. I just wanted to understand since I don't know. Your name?
Miss K. Burman.
A.
K. Burman.
Burman. I heard Miss A. Burman and counsel for the petitioner. It was Mr. P. Hazarika Lanet, standing also for the PNR department, has produced a copy of letter dated 6/5/2024, issued by the Commissioner from PNRD department to the Principal Secretary to the Government of Assam PNRD department, by which proposal for sanction of funds amounting to rupees 2,22,528 was made towards payment of arrear pay and allowances to the petitioner on account of the past services rendered by her husband, late Vishnu Boro, who had died in harness on 22/12/2018. from the
Senior clerical grade. Senior clerical grade.
the copy of the said instructions is already available on record. Next, it appears from the from another letter dated 4/4/2024 issued by the Commissioner from PNRD Department to the Principal Secretary to the Government of Assam, PNRD Department, that the
Exactly.
that the unauthorized absence from duty of the husband of the petitioner from 29/11/2011 till 22/12/2018 was treated as an extraordinary leave without pay. And that provisional death cum retirement gratuity has been sanctioned. And by the said letter, the government was also requested to provide instructions regarding sanction of compulsory family pension to the petitioner, and for releasing of the area leave salary and GIS subscription for the said period to the petitioner. I don't know why you take incomplete instructions. It's beyond my comprehension. In your letter, you write about the area salary and GIS. In the document enclosed, there is no reference to GIS.
But as far as this
I
letter goes, but there's been a-
I have so many times expressed. At times, we have a desire to ask all the departmental heads to come here and work here, so that at least we find that from 10:30 to 4:30, they are working. If this is the way they are doing it, the concern is that tomorrow I may also die. What will happen to my family? It's not that I have come with an eternal life. What happens? What happens if you suffer some difficulties and the retainership you earned till now is not paid to you for years together? And I'm saying this with some concern because unofficial information which we got is that even the government and panel lawyers have not been paid their remuneration for quite some time. If the government doesn't take care of you, they are not taking care of their deceased employees, they are not taking care of their employees. Question is, where is the rule of law? Then You see that even within 2 days, 2 weeks, if they don't furnish you with the particulars, on the 13th day, your commissioner would be here in court, personal appearance.
But there has been inaction on part of the commissioner, I admit.
No, I'm not on that. We are
2
not,
years old.
we are not, we are not digging up old, what you call, dead bodies. We are wanting to do something in this matter. What has happened earlier has happened. If they don't provide you with particulars, within 14 days, on the 15th day, your officer, your commissioner should be here with the entire records of the petitioner. And am I right? I'm asking you, although I should not ask, but is it true that the company and lawyers have also not been paid for quite some time? I'm not asking the time, but is it true? The timely payment has not been received. Out of politeness, you are not saying anything.
But as far as
But-
PNRD standing counsel is
It's
concerned,
okay, I am not asking you, it's a personal question. Finance is something I should not ask. But we take notice of everything. We also live in a gossiping world. I'm not immune to gossip. Walls have ears. At times we put our ears to the wall, we get so many information. And you know why I'm saying it? The issue is not of the finance. The issue is of there should be a timely redressal of the grievances of the people. It's not that X has got it, Y has not got it. If X is getting it and Y has not got it, the government should retrospect why Y has not got it. That's the only question. Why people should, for 2 lakh rupees, why should the petitioner be here? Next paragraph. We notice that the instructions produced by the PNRD department through the learned standing counsel appears to be incomplete. Because although there is a reference to arrears salary and GIS, there is no document appended to the instructions to show the status of the
Family
petitioners entitlement to GIS. Full stop. Although there is a reference to the provisional sanction of death cum retirement gratuity, but the said instructions are also not available. As to the quantum and the manner of processing of the said claims. Full stop. From the submissions made at the bar, the impression gathered by the court is that as the petitioner is a regular employee of the PNRD department, only in the event there is a lack of budgetary lack of budgetary allocation to the petitioner, to the PNRD department, only then the issue relating to payment of death cum retirement gratuity, arrears salary, etc., would reach the finance department. Full stop. Therefore, the impression gathered is that the principal secretary to the government of Assam, PNRD department, is the competent authority to issue requisite sanction. Next paragraph. If the department is aware that the husband of the petitioner had expired on what was the date?
22/12/2018.
22/12/2018. There's no explanation as to why the claims was first processed by the departmental authorities by letter dated 15/3/2022, issued by the in charge block development officer of Goroimari, GOROIMARI development block. Next paragraph. Therefore, the court is inclined to issue a direction upon the principal secretary to the government of Assam, PNRD department, to provide all necessary particulars and documents to the Legislative Standing Council, informing as to the various heads on which, under which prayer for issuance of sanction in respect of the petitioner, namely Srimati Alka Boro, ALAKA, Alka Boro, wife of late Vishnu Boro, expires no, you see, within bracket dead, was earlier working as senior assistant under the Goroimari development block, which would include the particulars about the request received, the amount quantified under various heads, and the reason for not issuing a sanction order despite the departmental request received. Full stop. It is also provided that if such instructions are not do not reach their learned standing council within a clear period of 14 days from today, which is which would be 19/6/2024, the commissioner, the principal secretary of the government of Assam, PNRD department, is directed to personally appear before this court on 21/6/2024, along with all relevant records relating to the financial claim of financial and any dues payable to the petitioner on account of claims under various heads, including death cum retirement gratuity, GIS, group insurance, and compassionate family pension, as well as any other head under which the petitioner may be entitled to. Next paragraph. The standing council for the PNRD department is requested to send a downloaded copy of this order to the principal secretary of the government of Assam, PNRD department, to bring the order to the notice of the said authority. In the earlier, the HUD census, as well as Mr. Arba then standing council for the finance department. Next, the copy of letter dated 6/5/2024, which produced by the learned standing council for the PNR department, is returned as said document is already available on record. Six, next person. This one 21/6/2024 for personal appearance of the principal secretary on his failure to provide necessary instructions to the learned standing counsel before the, on or before the date mentioned earlier.
Twenty-four.
Yes, APDC, what is your instructions?
I've received them. Subsequently, there have been certain developments, my lord. Some of the petitioners have been, their pay has been enhanced, my lord, because the direction in the judgment, my lord, that they're referring to is if they do not meet the eligibility criteria and as per the Uma Devi judgment, a suitable financial package may be granted to them.
Yes.
So that exercise has been undertaken. And as regards 20, out of the 28 petitioners before my lordship, 16 have been given the benefit of enhanced pay and 12 have not been given that much. So I'll perhaps have to place this through an affidavit.
Do you have the reasons why they were not given?
Those reasons I do not have.
It's not there.
I'll
No, it's
probably
okay.
have to get them.
Give them time to do it.
Yes, they may file an affidavit.
2 weeks time to join them.
And that may be given by, because some of the petitioners are getting near to their superannuation.
Okay. Okay. Heard Mr. O. Laskallan counsel for the petitioner. Mr. B. Chaudhary, learned standing counsel for the APDCL, has submitted that pursuant to order dated 19/12/2023, he has received instructions to the effect that pursuant to direction issued by this court by order dated 23/2/2021, passed in WPC 1351 of 2020. An exercise has been conducted by the APDCL authorities. And out of 29 petitioners,
16.
29 petitioners.
28
petitioners,
16 have been
of the petitioners have been granted enhanced pay package in terms of the order of this court.
Yes.
He submits that in the instructions received, there is no clarity as to why the others were not extended benefit. So we praise for some more time to obtain updated instructions and to file affidavit in opposition in the matter. How much time?
3 weeks, ma'am.
Give a date. We'll fix it on that day. Mr. Laskar is asking for a fixed date. Such an affidavit shall be filed at least 1 day prior to the next date of the state. Next file list on
26th or 27th June month.
26/6/2024. Okay.
And if you have
Obliged.
32.
Last order, Lordship,
May I
order
call
dated
it?
3/5/2024, Lordship. The sports and youth welfare was asked to get the vacancy position, Lordship.
Yes.
It is a second round of litigation, my lord. Although there is a specific direction from this court and also observed that there is a vacancy for the year 2007 and 8. My appointment was not.
You see, there are many difficulties. There are Supreme Court judgments which I have, not one, plenty. That once the vacancy, the list is over, the vacancy gets spilled over and it can't be spilled over. It will be a vacancy for the next recruitment process. So in a recruitment process of 2008, which is how many years now? 8, we are 24. How many years?
26.
No,
18, 16.
16 years. That list will have to be considered as expired. Even if there's a direction of this course, there will be no what you call the validity of the select list will not continue. So therefore, order of the court is, I can't say whether that can be implemented now or not, but then let us see what is your instructions.
Lordship, may kindly peruse page 105, Lordship. We have written to the
My lord,
Sports and Youth
last
Welfare
order, my lord,
Department.
they have asked the agriculture department as well as government also to asked from the Sports and Youth Welfare Department regarding the vacancies, my lord. They could not take the instruction even.
Let us say, let us take it that there are 100
Okay, that's
vacancies.
fine.
Let us understand that let us take it for a time being, there are 100 vacancies. But now, please come to this judgment. Which page is that judgment?
Judgment starts from page 49. Order dated 16/11/2021. In page 50, my lord, below paragraph, my lord, the operative portion there. Internal page 3 of the judgment. Because admittedly there was a vacancy for the year 2007 and 8.
Something is wrong somewhere. You might be able to follow it. Something is wrong somewhere. What is the date when your father died?
When 13 to 2005.
In 2005. Come to page 49. You got it recorded that the 2005 your father died. Recommendation by the SLC was on 11/9/2020 Before death, how could a DLC decision been taken for your appointment? Page 49, there's something wrong.
Page 49.
Page 49.
Yes, yes.
Recommendation by the DLC 2 years before your father died.
It is the judgment, my lord.
That's what I said. There's something wrong. I'm just pointing it out.
In the judgment, my lord.
Because I have to repeat it.
Our repetition is correct, my lord. Maybe it is inadvertent mistake.
Tell us what is the date.
It
DLC
may be
decision is when?
inadvertent mistakes. I have an annex date certificate also.
No, just tell us the date of DLC recommendation.
11/9/2013, Lordship, 13.
It is 13.
13.
11/9/2013.
13. Yes, what is the present current situation of vacancies?
Lordship, from the sports department, Lordship, need some time, Lordship, 1 week time for submitting the present status.
For vacancy, you need time.
My
You must be maintaining a register of vacancies.
Lordship,
Three occasions, my lord. Even if you file an RTA, my lord, then reply will come within a month.
You see, the answer is very simple. It's not very difficult. When there's a judicial order, therefore we are asking him. 2003 or 2005 vacancies will not be available now. They don't, I have not found any mechanism in the state government where they would continue to reflect a vacancy of 2009 when there are thousands of compassionate appointment cases pending in the court. It will not be available.
But they can tell the court how many vacancies still.
Please try to understand the query. You see, please tell me what was we'll reframe the questions. Now tell us, in 2003, when your father died, what was the condition in the OM? It was the vacancy of the year in which your father died.
Yes.
Correct?
Yes.
That is 2003. The DLC could not have given a recommendation for the vacancies arising in 2007. So that would be earmarked for people whose father died in 2007. The respondents were not vigilant and allowed this to be made a part of the judgment of this court. Now we are bound by that judgment. It says 2007. Now 2007 is how many years from now? 2007 from now would be 18 years, 17 years?
17 years.
Correct. I don't expect a 17-year vacancy to be remaining in a department like that when there are so brilliant officers who are ready to give appointments left, right, and center.
Right.
Correct. I don't expect any vacancy to be remaining of that year. This one. Second is, how do you overcome, even there is a judicial pronouncement of this court of 16/11/2021. How do you overcome the judgment of Supreme Court now given in the case of Devabrata Tiwari? It says that you can't do it. Now, second question. Achyut Ranjan Das said that after Principle 10, it should be a spent force. Therefore, for this court to implement this order of 16/11/2021, with all respect, I would be guided by the earlier order of Achyut Ranjan Das. Third thing is that the OM of 1/6/2015 refers to Principle 10. Now it says that the Supreme Court judgment in Sanjay Kumar, it is very clear that the date on which the application is considered would be the applicable OM. Correct. Now, under that OM, again the Principle 10 has come in that after 2 years it will not be required to be considered. Then please show me a way to implement this order of 16/11/2021 of this court.
The second SLC also recommended my name, my lord.
No,
It was in the
recommendation you may have. Recommendations you may have. You still recommend it now. The question is, how do you overcome the judicial pronouncement of two pronouncements which I have referred to? How do you overcome that? How do we say that the Supreme Court judgment is not binding on us, and therefore we implement the order of the single judge of 16/11/2021? How do we say that?
But I have approached before the court in the year 2015.
No,
It
that
is a
is-
long pending case, my lord. That is
That
not
is
my
okay,
fault.
but you have heard the question. I'm asking you, show us a way. Show us a way how we can say that the Supreme Court judgment is not binding on us when under 141, it's by the pronouncement of the Supreme Court is binding on us.
Well, at this stage, let them produce the vacancy, my
It will
lord.
never come. It's something which will never come. Even if we permit you to go and search in their office, you will not be getting it. The reason is, you see, you get a statistics. You take out the register of two thousand
And my
seven.
lord, in that,
No, please to understand, we must be practical, we must know how to work. If you want an order of the court, you must also explain to the court how the system will work. Number one, in a department, the existing vacancies of the year will be shown. There's no system of, subject to, you all are more acquainted with service law than I am. You have to say that the vacancies of 2007 will, what do you call, when the appointments are made, when these are made, it is the year-wise vacancies which are available. How will that be adjusted in this year? Because we do recruitment in the High Court. We don't show that there is a vacancy available for the year 2007. All those vacancies are merged with this present, and when we now issue a recruitment notification, we say that existing vacancy is so and so. We don't refer to a vacancy for being filled up by indicating in the advertisement that this is the vacancy of 2008, this is the vacancy of 2009, this is the vacancy of 2021. We don't do it.
And my lord, in the judgment, there is an one person, Deepak Paswan, his reference also made here. He, even though there is no vacancy, my lord, he has been appointed, my lord.
Negative equality, please don't argue. You'll have to,
Vacancies are merged,
much,
Lordship,
you'll
that
have
is the point.
to make much more submissions when you
And the same
refer to
thing,
negative
that's
equality.
right.
Two wrongs don't make it a right. Negative equality, you'll have to give some more substantive argument than saying that. I've given you three things. Number one, we say that Devrata Tiwari. Second is Achyut Ranjan Das. Third is the OM of 1/6/2015. These principles are there. In light of this principle, please explain it to us how we overcome this two legal bar. Your addressers will pass the orders. We don't want the vacancy. These vacancies for 2007 will not be available. The reason is they are not one. There are hundreds of judgments which says that once a recruitment process lapses or is completed, then those vacancies which are available will be for the new recruitment process. The recruitment process cannot travel back. Somebody in the select list of 2021 cannot come and say that, well, this vacancy of 2021 was not filled up and therefore please give it to me. That will be rolled over to the next recruitment process. That is the law which I have understood. I may be wrong. I again say that service is not it's something which I have not done. You have expressed like my compatriot here, Mr. Bhagwati, more seasoned than I am. Yes, anybody, Mr. Babujari, what do you give an independent view of the query raised by the court?
Definitely,
It's an independent
I
view.
have heard what has fallen from my lord's mouth. Everything is circumscribed within the meaning of Article 16. Because Article 16, my lord says, my lord, because that vacancy has to be carried forward. It cannot be put back. So it will be in violation of Article 16. If we raise that argument. That's it, my lord.
Your addressers will hear you. We'll take it up next day because we are now out of time.
Moreover, Lordship, Agriculture Department do not have any vacancy. We have passed it in the state level.
We produce that letter. Why you're not producing
Page
it?
86, Lordship. Page 86, Lordship.
Page 86.
Lordship. Right side column, Lordship, last lines. Since the Agriculture Department do not have any grade 4 vacant posts within 5% of the cadre strength, therefore the department shall take up the matter to accommodate in consultation with the with other departments against the vacant posts. That is because of the personnel department OM, Lordship.
86.
86,
I couldn't get it. There.
Right side, Lordship, right side.
Right
column,
side.
Column, the last column, Lordship.
The DLC.
Before that, Lordship. Since agriculture department do not have any grade 4 vacant
Oh, it's a
posts
small,
within
in-
yes,
small,
yes,
small,
Lordship.
small,
Yes, Lordship.
since agriculture department.
Do not have any grade 4 vacant posts within 5% of the
department.
cadre strength. Therefore, the department shall take up the matter to accommodate in consultation with the department against a available vacant post. It
Okay.
is because of the personal department, no, Lordship.
So this agriculture goes.
Yes, Lord.
Now what is left?
Other department. As per the OM.
It's a never ending exercise.
And they have stated that some posts are lying vacant in the sports and youth welfare department.
I think not less than 10,000 compassionate appointment cases are pending. We won't expect 2007-8 vacancies of any department to be available. Since the day I joined here, we have been only handling this compassionate appointment cases. It will just not be available. This is an inquiry. If we start doing it, it will not be never ending. How many departments are there? We don't know. How many departments would be there in the state government? About let us say 20, 25?
25 plus.
25, let's say 30 departments. So all these 30 departments will have to give a year-wise vacancy to us.
These vacancies, my lord, will stand extinguished both by, my lord, efflux of time as well as by operation of law. That is the admitted policy. I mean, my lord.
You tell us the way to go about how to do it, how to implement the order of the court. You give a suggestion. We'll take it up day after tomorrow. Just right.
My lord, 1 week after, my lord, I have to
Okay.
some preparation.
Mr. D. Borat and counsel for the petitioner submits that despite the judgment and order dated 16/11/2021 passed by this court in WPC 4342 of 2015, the exercise is directed by the said order has not been brought to its logical conclusion inasmuch as this SLC did not sit according to you. The direction of this court is to have it before the DLC, the SLC,
SLC said, Lordship, page 86, I showed just now, Lordship.
86.
Yes, Lordship.
Mm,
20th February 2023, Lordship. Page
Yeah,
80 is the mind notes of the SLC.
That SLC also extract, we have also enclosed. Annexure of page 57A.
Annexure 3 of my affidavit in opposition.
And the type copy is page 57.
As the SLC, which had held its meeting on compassionate ground on 22/2023,
It was reflected the SLC has recommended personal OM departments OM dated 1615. Lordship may peruse my petition also. That was, I have typed, my lord, page 57. Page 57. No? 57, yeah, 57, 82.
Page number
57. And SRO type copy in my petition.
merely directed the concerned department to take up the matter to accommodate the petitioner in consultation with
With
other
other
department
department.
against an available grade 4 vacant
Vacant
post. Next paragraph. You've heard Ms.
Arboral.
R. Boral, and standing counsel for the Agriculture Department, as well as Mr. J.C. Goswami, Leonard, government advocate.
1 and 5 loads.
Only you two are here. In this matter, for respondents, only you two are here.
Yes.
Okay.
No, it should be five. Yes.
1 and 5.
Finance also there, my lord.
Finance, no, not there.
I've not seen the cost titles.
No.
Next paragraph.
Government and Agriculture Department.
It appears from the legal position as it stands now that the Supreme Court of India in the case of State of West Bengal versus Devabrata Tiwari. Petition is there, huh? Has held that any delay in the consideration of the application for compassionate appointment, even if the delay is attributed to the state, will disentitle further consideration. This court, in the case of Achievement and Das versus State of Assam and others, take citation from one second, has also held in subpara 10 of paragraph 7 of the said judgment that an application which remains pending for consideration for a period of 2 years shall require no further consideration and shall be considered as a spent force. Stop. In light of the said pronouncements, it appears from the material available on record that the father of the petitioner had expired in the year 2005. And the DLC recommendation to the petitioner was made in the year 2013. First of however, however, in respect of vacancies which arose in the establishment of the, what is the establishment? Agriculture Department.
Not sure.
The Agriculture Department. Of the year 2007-8. As per the government policy in force at the relevant time, the vacancies which could have been filled up under 5% quota for compassionate appointment was the vacancies which were available for the year in which the government servant had died. Full stop. There are several judgments of this court as well as the Supreme Court of India that the appointment on compassionate ground must strictly be in adherence to the policy in force at the time of consideration. Full stop. Therefore, in 2000, therefore, full stop. Next para. Under such circumstances and legal position which is available on date, in legal position as on date, comma, the learned counsel for the petitioner is asked to make his submissions on the said issues. Next para. It may be mentioned that the learned standing counsel for the Agriculture Department, by referring to the SLC minutes referred above, has submitted that the departmental stand was very clear that there is no vacancy available for the year 2007 to accommodate the petitioner. Stop. Next para. List on when?
7th.
After a week.
List after a week as per.
And my lord, last order court has asked to the vacancy positions of other departments, my lord, not for the year 2007 and 8. It was specifically written in the order, my lord. They have asked the government.
You tell us the legal position. Tell us the legal position. Supposing we ask them, today they have given me a figure, 100 in different vacancies.
Right.
But now tell us how to put you in.
At first, let them file the vacancy positions, my lord.
No,
Then
this will never come. It will never come, and then at one point of time, we will be compelled to pass orders taking adverse view against the government on the ground that it's not available, because it will never be available. There is no statistical system in place in the state of Assam where vacancies arising and the appointments made are correlated, and then what you call a statistical presentation is made.
But my lord, I have filed application in due time, my lord, within 1 year, my lord. And DLC recommended my name lately, my lord. Then I came to the court.
You conclude your argument. You conclude your argument, will pass the order. You conclude your argument.
Yes, my lord. Next.
No. This conclude. You see, don't go dissatisfied, Mr. Vora. You will think that the court is not hearing you. You will adjourn otherwise it is fight.
No, it is time.
Okay, I take the opportunity of requesting all the members of the we are not taking up any other matters. It is already past time. If there is any interim order to be extended, please tell the court master. No, you see, we have passed an order, but you said that you make your submissions. Now, please conclude your submissions. We'll pass orders. If they have not produced, we'll take adverse opinion against them. We'll draw an adverse inference that they have not produced the document.
Hello, I will satisfy the court next week.
Submit. We could have done something better. I'm not adverse to hearing. In this court, I have set till 8:30 in the evening. So don't think that I'll be I'll be afraid of sitting longer time. It's not an issue. We're closing it because of the different factors. Because we don't have these details, and I'm asking a legal question. What happens to that order is a different aspect altogether. We're not insisting on the implementation of that order right now. We don't have a system. You have to first show us that there is a system in place where we maintain a vacancy position of 2007. It's not required. There's several reasons, Mr. Bora. I don't know whether you are aware or not, but a vacancy position of a state government department is not an essential document which is required to be preserved for more than 7 years, 8 years. It is under the executive, what do you call, executive rules of business. It's not required. So if I'm asking for that document which is not required to be maintained, I'll be getting a sorry figure. So these things are elementary. They may not take it for many reasons. People may not remember. But it's the rules of executive business, something which prescribes a period of limitation of keeping a record. We don't have that system. It's not the government is not a court of record. It does not keep a record. So to ask a vacancy, and then you'll ask that this vacancy arose out of death or retirement of which person, is something which will not be available. It is only when they are.
But in the last SLC.
It is only when they appoint people under a separate, under a definite vacancy, then they are required to write in the order because of the requirement of law of an appointing officer, because if it's a casual vacancy, it can be filled up by any authority. If it's a regular vacancy, it will be appointed by by the head of the department. So these things are, we know about that. This much of service law I have learned from all of you. Correct. Okay, this one, this after week is before. Yes. Yes.
Item 56.
Yes, Mr. Bhagwati. Mr. Bhagwati.
So next item, item 33, Lordship. That date will be fixed, Lordship.
Okay. We'll make some adjustments.
Much obliged.
Similarly, 46, some adjustments there on favor of pensionary benefits.
Oh, 46 will give it. 46 to begin. Date. 46 will fix a date. Okay.
Obliged.
That's okay. We are obliged, always obliged.
You'll be having difficulty in again second round at your chambers.